It's not mentioned. No instruction.
How many days delay? Get ready and mention. February.
Restoration application dismissed for default on 4/10/2023 and within time on 16/10.
Reading application did. I do call them. 17th, 16th did application, 16th did notice.
Secondary higher department of this. And
Secondary hearing, March monthly list. Hearing secondary, March monthly list. আজ এটা ফেব্রুয়ারি দিয়ে দিচ্ছি ইন পার্সন মেনশন করেছেন ফেব্রুয়ারি দিয়ে ফেব্রুয়ারি মান্থলি লিস্ট yes application for
substitution by condoning the
delay condone.
They are always on my ladder to place the judgment and I also place the judgment. It is that center where it is further there is a delay. And substitution application is there, but without any application of private. Your lordships, once the judgment that whether the substitution application for setting aside abatement application is required, that was required. While at my learned friend cited the judgment, it is not required. I relied upon the judgment in 1965 Calcutta, where it is stated a discretion of it. And my friend is also relied upon the Supreme Court judgment, where it is specifically stated it's a discretion of it. But in a strict sense, in a writ proceedings, application for there will be automatic.
No automatic.
Your lordship is fix the matter from judgment or giving. I think
Very well, you place the application. Judgment গুলো কোথায়? We are hearing now. See a can. What was the nature of the writ petition?
The petitioner was the suspended headmaster of the school. Yes, filed two writ petitions. One is challenging the suspension, another challenging the disciplinary procedure. Within the pendency of the writ petition and before attaining the age of supervision, petitioner.
It is
Petitioner died. When writ petitioner died. Within the pendency of the writ petition and before attaining the age of supervision.
Pending. Application is not
because this petition is pending. First, because after the death, petitioner wife went at the office of the district inspector of district. He told him, he told her that file some documents through the school. We will release the pension. School also filed documents after taking documents from the widow. But here has not yet been released the pension or any amount that come which are because these two petitions are pending. The school is always cooperative with us after the death of the petitioner.
Which can you place?
Can 3 2022 interaction 2 WPA
Can
3
WPA 23
957 of 20.
Can very good.
Substitution application.
Condonation of delay. Condonation has also not been allowed. Very good.
You can see, my lord, can see of 2020 in connection with WPA 23957 of 2027 at page 9. I have annexed the
1 second.
death certificate.
এই কোটে আমাদের শ্রেডার দেই না? Yes. First condonation. Condonation is
342 days.
no. Can. I will dispose of the applications today itself.
Can two of 2022 in connection with WPA 23957 of
1 second. Can two. Yes, in a nutshell, give me the facts.
But I have next.
No, first you tell me. Then I will do
The
the
petitioner within the pendency of the writ petition.
original writ petition.
Original writ petition.
Yes, petitioner was the headmaster of a school. Due to some misbehavior with the school authority and some assistant teacher, disciplinary proceedings initiated by the then managing director of the school.
Only this allegation.
No, there are certain other allegations.
Any serious allegation, defalcation of
No.
fund?
No, there is not.
But actually, there was an allegation. There was the allegation. She wrote letter to the bank not to disburse any amount for daily daily expenses borne by the school authority, and for the act of the headmaster, the school authority faced certain difficulties with regards to
Expenditure.
and running of midday meal program in the school. All these allegations are there, and thereafter, the then managing committee of the school issued suspension letter, and subsequently issued so-called notice. So, charge sheet. Challenging the order of suspension.
You are in the state panel. Then
Challenging the order of suspension, the petitioner filed on it. Thereafter, there was no interim order was passed. Since there was no interim order, the school authority proceeded the matter, and given him charge sheet, and one inquiry officer was appointed for proper inquiry of the matter. And total inquiry proceedings was challenged by filing the second petition by the writ petition.
this is the one. 2-3 something.
Yes. And
what happened to the first petition?
That is also pending.
That is number?
WPA 22075 of
Okay.
2007. Both are appearing before your lords. Both the writ petitions are appearing before your lords.
No.
22075.
What's yes. So if I take up the second writ petition and proceed on that, then automatically the result will abide the first writ petition. All right.
Thereafter,
Right, Mr. Counsel?
Thereafter,
As this petition
inquiry
challenge on the visit to reproceed.
And second writ petition?
Challenge in suspension.
All right, we will come later. First, let me concentrate on this. Yes.
Thereafter, inquiry officer concluded the inquiry. But there was an interim order by the honorable court not to publish the inquiry report and ultimately matter was taken up for hearing by the Honorable Justice and pursuant to the leave granted by the Honorable Court, my Lord, School Authority, as well as the inquiry officer, forwarded the inquiry reports before the West Bengal Board of Secondary Education for taking appropriate steps. So, my Lord, entire inquiry is now pending. So, my Lord, since that disciplinary proceedings is pending today, in spite of the date of the original petition,
Now the legal heirs want to contest.
legal heirs want to not
Contest.
not want to
Ask.
they are wanting
I'm coming.
they are wanting for release of family member. Since the petitions are pending, district inspector of school is not in a position to disperse the
Now tell me the law. Let's say disciplinary proceeding pending.
pending.
All of you, please apprise me. I want to narrow down the concept. Disciplinary proceeding pending. Admitted fact. Admitted fact, original writ petitioner teacher died. Admitted fact, because of the pendency of the disciplinary proceeding, no funding was released, whatever. Two writ petition fact. First one, challenging the initiation of the disciplinary proceedings. Please listen to me carefully, forget it. Secondly, challenging the result resulted in suspension.
Yes.
So two different writ petitions. Now, if the court embarked upon these two writ petitions, then the disciplinary proceeding pending before the board, who is equally a fact-finding inquiry, it will be jeopardized. It will be usurped. The jurisdiction will be usurped. The law is, I have read now by this time, and which I have also read after your judgments being placed, that legal heirs are permitted to contest. Legal heirs are permitted to contest. How to contest? What should be the procedure? Matter is pending before the board, they will decide. Now, Mr. Counsel for the petitioner, listen to me carefully. If today I allow you and you will be allowed to contest the disciplinary proceeding before the board, then with this limited direction, can the court dispose of these two writ petitions with a rider that the court has not gone into the merits of the disciplinary proceeding and the challenge of the disciplinary proceeding, since the disciplinary proceeding is pending before the board? However, legal heirs are permitted to contest. And after the final result comes in the disciplinary proceeding, if the legal heirs are agreed, they will be at liberty to take steps in accordance with law. Can that be done?
My Lord, may I,
1 second, I am coming one by one. Can that be done? What do you say?
My Lord,
Is after all his carriage of proceeding. Let me hear.
in the year 2017, matter filed before this honorable.
Oh, Mr. Counsel, forget about all those. Whenever it is filed, not filed, forget it. I said that the admitted fact is disciplinary proceeding pending. Pendency of the disciplinary proceeding, two challenges in two sets of writ petition. Pendency of the writ petition, original writ petition are that. Now, if I allow you substituting in these two writ petitions and allow you to contest before the board, right? And dispose of this writ petition with an observation, at this stage, court shall not go into the merits of the disciplinary proceeding, because it requires some fact-finding inquiry which is not the job of the writ court, it will be done by the appropriate authority.
Both.
Whoever,
Lordship.
whoever, both, very well, both. This court has equally not gone into the merits of the writ petition, right? However, if the contestee is aggrieved by the final result of the disciplinary proceeding to be taken by the board, they will be at liberty to take steps in accordance with law.
And mine can add one right.
1 minute, 1 minute. First, let me understand his mind.
In 2018, government also made such rules. But what is the discretion power?
Ore Baba, I have
Lordship.
seen.
Yes, I agree with your lordship.
Agree?
Lordship.
1 second.
Finally, our application can add also a rider to that effect that if the decision goes in favor not approving, then
That's right. If the disciplinary proceeding is negative,
then consequent steps should
of course, consequential or benefit should be given.
And
Rider, I will add.
Hey.
Yes, now you take.
But lordship, kindly record that during pendency of the petition which is about that that's and
Lord, may I suggest one
What?
for attending the
What did I say?
lordship.
You will hear when I will pass on. Yes.
subject to correction by your lordship. The repetition challenging the order of suspension is now in practice.
Why?
Died in the meantime.
Correct.
So there will
Second bit goes.
second. On the first read, my lord,
Genesis of the disciplinary proceeding challenged in the first rate. It will abide by the. It will be decided by the board.
yes, my lord. May I?
My lord, first rate challenging the disciplinary proceedings.
He is saying.
Challenging the
He is saying the same thing. Listen carefully.
lordship.
Lord, secondly, my lord, court is not the party respondent. And my lord,
করেছেন তো?
হ্যাঁ অন করেছি
করেছেন?
হ্যাঁ
অন করে দেবেন। আমি আসার পর অন করে
আচ্ছা
court is not the party respondent. My lord, may I suggest one thing, my lord, kindly delay the board to consider the issue, my lord, keeping the repetition pending. Since the family is suffering, my lord, since 2019, but if the repetition being disposed of, my lord, board will not take any steps and a further round of litigation will be created for filing of the contempt application. And-
No, but one
and
thing
the
I tell you,
and
one thing I tell you, excellent submission. Very fair submission.
And by this
But
time,
one thing I tell you, if a result comes, a result will have to come. It's way that way. Right? Either disciplinary proceeding will remain and proceed and final result will be upheld, or they will be acquitted. Then the principal character of the first writ petition will be changed. What will happen?
Limited argument and limited pleading is there. And if it goes in favor of the, then also my lord cannot execute because of lacking of the pleading.
and my lord, inquiry officer is not a recommending authority, my lord, who recommends the punishment. But at that point of time, the managing committee was the recommended, was my lord, entrusted the power for
Sir,
recommendation of punishment.
Mr. Rai, these are not to be considered at this stage. The moment I will listen all these, I will go into the merit. I will not go into it. What I am saying, I will give it the board a time-bound program. Within 8 weeks, let's say within 8 weeks, or 6 weeks, or 10 weeks.
For 6 is.
Very good. I will submit.
And by this time, she is entitled, the family is entitled to get the provisional pension under the DCRB rules. my lord.
Pension কি করে হবে? Pension আর একটা
Provisional provision. And provisional family pension.
6 weeks এর মধ্যে decide হয়ে
No, I will not do. I will simply direct to decide it
যাবে।
and make a final result, whatever, this way, that. And with the liberty, he will be able to challenge the final result if it goes against him in accordance with law. Ashu.
My lord, is correct. Act is the petitioner, when petitioner expert for out before the disciplinary procedure.
That will take point there.
Yes.
All points shall be kept open. So that you can get the relief.
Yes.
At the next you tell me, you show me, all of you, your duty. Now, that is the court. Give me the best of the judgment. One. That legal heir will have a right. You consult and then give me the best of the one. That I will consider that judgment. That is the thing.
I have placed a judgment matter 1996 question.
I will come. You talk amongst yourself then. Mr. Counsel for the petitioner, you assist me in recording a fact. Right? একই দুটো রিট পিটিশন একসঙ্গে হচ্ছে Can 2 of 2020. This is an application for condonation of delay for about 342 days. Seeking abatement of a writ petition, being WPA 23957 within bracket 2007. Bracket is hereinafter shall be referred to as the second writ petition. But before that, I have to first set aside the amendments, a abatement. The petition must come on the board. Full stop. The facts relevant for adjudication are narrated, are only narrated here. Tell me. The petitioner was working as an assistant teacher and
Headmaster.
assistant teacher to what is? Then headmaster. Post is headmaster. The petitioner was working as a headmaster at one, give me the school name. কোনো তাড়াহুড়ো নেই, আস্তে আস্তে অর্ডার করবো কারণ এটা
South Villa High School.
South
Villa.
spell out.
BUILLYH.
Villa
High School.
High School
Within bracket HS.
HS District
Howrah.
House. Bracket for short the school. While serving as an headmaster, the record reveals that he had suffered the original writ petitioner. আচ্ছা শুরুটা কিভাবে করেছি?
The petitioner was
Petition একটা হবে original writ petition. The original writ petition.
the original petitioner was working as a headmaster at one South Villa High School, HS District Howrah, within the for short the school. While serving as a headmaster,
While serving
while serving as a
তো
headmaster.
আপনি একই অবস্থা হ্যাঁ।
The record reveals that the original petition
had suffered a disciplinary proceeding which resulted into suspension of the original writ petition. The principal charge, please, all of you, please listen carefully. The principal charge against the original writ petitioner was that was inter alia that he had lodged a complaint before the banker of the school with a request not to allow the managing committee of the school to expend money therefrom, which was according to the original petitioner not being utilized in a proper manner, as it was required to be done for running the affair of the school. The writ petitioner challenging this initiation and initiation of and the continuation of the disciplinary proceeding find a writ petition being WPA
239.
no 239 WPA
Not 22075.
that is why I'm asking, please listen carefully.
2075.
WPA bold করবেন এটা 22075 within bracket W of 2017. Bracketing hereinafter referred to as the first writ petition. The same is also pending. The same is pending before this. Arising out of the same disciplinary proceeding, the original petitioner then suffered this order of suspension dated
Managing committee resolution dated 25th of
under the resolution of the managing committee dated November 25, 2016. Bold করবেন suspension order bold. Suspension order কথাটা bold থাকবে, এটা bold থাকবে date. The writ petitioner then filed the second writ petition being WPA 23957 of 2017 as already referred to above. This is also paid before this. During pendency of these two writ petitions, the original writ petitioner died on
29 December 2021.
December 29, 2021. Full stop. The legal heirs filed an application for substitution in the second writ petition being can substitution
Can see substitution. Can see substitution application can see legal.
Can 3 of 2022. In view of the delay for about 342 days in filing the said substitution application from the date of the death of the original writ petitioner, the instant application Can 2 of 2022 was taken out, paying for condonation of delay and setting aside of the event. Correct. What's your name? Mr. Obijit Chakraborty, learned advocate appearing for the legal heirs who are the applicant before this court today, submits that the disciplinary proceeding is still pending before the West Bengal Board of, before the appropriate authority of the West Bengal Board of
Secondary education.
West Bengal Board of Secondary Education.
And the report of the disciplinary inquiry authority has already forwarded by the school authority before the for taking action.
I will report it. Full stop. However, the board is not included in the original, in the writ petitions. Both.
Yes, because at that time board was not discussed.
Correct. It was not placed before the board. Correct. Full stop. অন্য রিটটা কবে হয়েছিল? এটা তো সেকেন্ড রিটটা 2007 এর। অন্য রিটটা
And that is also 2005.
আমি এখন সেতুর দিকে একটা নাস্তিক এটা একটু বলতে হবে কেন দিচ্ছি কি বললাম?
That effects before this court today said the disciplinary proceeding is still pending before the appropriate authority of the West Bengal secondary education.
এটা বলতে হবে ওয়েস্ট বেঙ্গল বোর্ড অফ সেকেন্ডারি এডুকেশন ব্র্যাকেটে ফর শর্ট দ্য বোর্ড full stop. However, comma, the board is not included in the writ petition. In the writ petitions. Paragraph. Give me the best. দাঁড়া তারপর কি বললাম? ওর সাবমিশনটা বলুন। আচ্ছা, ওটা তো ওর সাবমিশনই হবে। Full stop. Learned counsel for the petitioner submits that applicants, petitioner legal heir applicants submits that the legal heir has a right to proceed and contest the disciplinary proceeding, since the initiation, and continuation thereof, including the result of suspension of the original petitioner, was illegal and or without jurisdiction per se. Mr. Sumit Kumar Ray, learned counsel appearing for respondent numbers.
5 to 12.
Who are those, sir?
School authority.
5 to 12. Being the school authority submits that as a paragraph. The school authority has forwarded all the documents pertaining to the disciplinary proceeding including the inquiry report dated
Mother. Dated, mother. Forward it on.
including the inquiry report prepared by the inquiry officer
Inquiry option.
before the board, and the board is in session of the disciplinary procedure. He submits that to come to a logical conclusion of the said disciplinary proceeding, some fact-finding inquiry are also required to be made, for which the board is the appropriate authority. This is your submission. Mr. Das, Mr. Gaurav Das, Learned Counsel appearing for respondent numbers 1, 2, 2, 3, submits that the state authority has no role to play at this juncture until and unless the disciplinary proceeding reaches at its logical conclusion. Fact. After considering the rival contentions of the parties and on perusal of the materials on record, this court first proceeds to discuss the law as to whether substitution of the legal heirs are permitted in the fact situation of this case.
May I supply the mark?
Fine. What does it say? Discussion of the court.
Yes.
Read.
Para 6, 7, 8, 10 is
Read. Close.
After consideration, I was.
Show me. 6, 7.
relevant para is 6, 7, 8, 10 and 12. In para 12 specific
Let me read once.
order to entry of the court is not applicable to the reproceedings or writ appeal. It does not mean that the petitioner or the appellant in such petition or writ appeal can ignore the date of the respondent if the right pursue the remedy even after the date of the respondent or subject. After the date of the respondent,
Thank you.
After considering the rival contentions of the practice and on perusal of the material from record, so first proceeds to discuss the law as to whether the substitution of the legal heirs are permitted in the fact situation of this case.
Fine. In the matter of legal, Puran Singh and others reported at the meeting. You are already looking.
What exactly starts happening cancer?
You will know.
In the matter of Puran Singh and others versus State of Punjab and others reported at 1996 to SEC 2005.
You will download the Supreme Court in the matter of such and such. In the matter of such and such, the Honorable Supreme Court had observed as under. Quote paragraphs 5. Which of the paragraphs?
6, 7, 8, 10 and 12.
6, 7, 8, 10, 12. Para 6, 7, 8, 10. I don't quote codes. proceeding. The law is thus that the rigor of Order 22, Order Roman 22, bold, of the Code of Civil Procedure is not applicable to a writ proceeding or writ appeals, to a writ proceeding. But that does not mean the petitioner or the petitioner in the writ petition can ignore the depth of the deceased party if ultimately the right of the legal heir survives. In the fact of this case, because of the pendency of the disciplinary proceeding, which was initiated during the lifetime of the original writ petitioner, was challenged by the writ petitioner during his lifetime. The initiative, the original writ petitioner. And he moved.
In the fact of this is, because of the pendency of the disciplinary proceeding which was initiated during the lifetime of the original writ petitioner, was challenged by the
Original writ petitioner
during his lifetime.
But during pendency of such challenge in these two writ petitions, he had died. All his employment benefits are stuck and withheld by the state authority because of pendency of the said disciplinary procedure. The legal heirs definitely have a right to claim the retirement benefit of the deceased original writ petitioner. And to establish that right or to have it negated in the established procedure of law, the legal heirs shall have a right to contest the said disciplinary procedure. If the disciplinary proceeding does not survive on merit, then of course the legal heirs, the right of the legal heirs would accrue to receive the employment benefit of the original writ petitioner. And if the disciplinary proceeding succeeds, then the law shall take its own course. Right? If the disciplinary proceeding succeeds, then the law will take its own course. Back. In view of the foregoing reasons and discussions, this court is of the considered view that the legal heirs who are the applicants before this court shall be granted an opportunity shall have a right to contest the disciplinary proceeding and these two writ petitions. Further. For the foregoing reasons, the delay for about for the foregoing, inasmuch as unless the delay is condoned and the abatement is not set aside in the writ proceedings, pending two writ proceedings, the legal heirs who are the applicants before this court having a substantive right shall be prejudiced and their right cannot be taken away. And such a valuable right cannot be taken away under the rigor of procedural law. Paragraph. For the foregoing reasons, this court is of the considered view that the delay occurred in applying for setting aside of abatement, if any, comma, if any, comma, shall have to be condoned. Paragraph. Accordingly, the delay stands condoned and abatement, comma, if any, in the writ proceeding. You have taken out one application in this second writ petition or similar application in both.
One is for condonation of delay, another for substitution.
In the second writ petition.
Both.
In both.
Both.
Good stuff. Ki bolla?
According to the said condon and abatement if any in the writ proceeding.
Stand set aside. State stand set aside. Good stuff. Accordingly, Can 2 of 2022 filed in WPA 23957 of 2017 and second can in the first writ petition. দাঁড়ান অন্য রিট পিটিশনে যেটা কন্ডোনেশন চাইছে অ্যাবেটমেন্ট সেট সাইড চাইছে
Can 2 of 2022 in WPA number 2075 of 2027.
bold
This is for substitution.
Stand allowed. No. First writ, is there any condonation application? So give that number.
Can 1 of 2022
Say correctly, listen correctly.
and 20.
Can 1 of 2022, please help me. Can 1 of 2022 finding WPA
075 of 2027.
stand allowed. Comma without any order as to courts. Full stop. Paragraph. You have to cause the substitution. Otherwise, no order can be kept in the rate. Full stop.
Substitution is also there. Okay.
Paragraph.
Yes. They have
Acha, next korun in rate. Tell me the substitution application. Can
Can 2 of 2022 in connection with WPA 22075 of 2027. This is substitution.
all right. Likho. This is an application for substitution filed in the second writ petition. Full stop. In view of the observation and order passed by this court in Can 2 of 2022, this application stands allowed. Full stop. Accordingly, substitution can 1, can 3, what? কোনটা অর্ডার করছে?
Second, in connection with second repetition, why not substitution?
First একটা করছে, first একটা হচ্ছে
না না সে না
Second repetition.
সেকেন্ড রিপিটিশনে ক্যান টু হচ্ছে কন্ডোনেশন অফ ডিলে
And can 3 is substitution.
second
সে দ্যাট ক্যান থ্রি ইন
Can 3 can 3 of 2022 in connection with WPA 23957 of 2017.
লিখুন ক্যান ইন রে ক্যান
In can 3 of 2022
ইন
in WPA number 23957 of 2027.
2070
70. Sorry. Is
Hello.
this is substitution?
হ্যাঁ এটা লিখুন দিস ইজ এ সাবস্টিটিউশন অ্যাপ্লিকেশন লিখেন করে কি বললেন
This is an application for substitution filed in the second repetition in view of the observation and order passed by this court in Can 3 of 2022. This application
Can 3 of 2022 find in WPA 23957 of 2017. This application stands alone. Hello.
stands
আচ্ছা পরেরটা লিখুন ইন রে এবার ফার্স্ট রিপিটিশনের সাবস্টিটিউশন কন্ডোনেশন অ্যাপ্লিকেশনের নম্বর কত ক্যান 1 of 2022 in WPA
22075 of 2017.
লিখুন নিচে in view of the observation made by and order passed by this court in Can 2 of 2022 find in WPA 23957 of 2017. This application being Can 1, Mr. Das and Rai, help me.
can one of
one of
Can 1 of 2022
in WPA 2575 of 2017.
220
22075
of 2020 stands allowed. Next, in ray substitution. Can 2 of 2022 in WPA
22075 of 2017.
ঠিক আছে করুন in view of the observation made by this court and the order passed in Can 2 of 2022 and Can 3 of 2022 in WPA 23957 of 2017. The substitution application being Can 1 of
2020
22
in
filed in WPA such
2075 of 2007.
stands allowed. Paragraph. The petitioner, the applicant legal heirs shall cause the necessary substitution in the original two writ petitions, namely ওই দুটো রিট পিটিশনের আবার নাম্বার দিন কোনটা 220 করে দিন পরেরটা 23957 ঠিক আছে কি বললাম
the applicant's legal heirs shall cause the necessary substitution in the original two writ petitions, namely WP 2075 of 17.
in accordance with law. Full stop. Paragraph. The applicant legal heirs shall also implead the West Bengal Board of Secondary Education to its appropriate authority as a party respondent in both the writ petitions for the ends of justice. Paragraph. After carrying out the entire exercise, after carrying out and completion of the entire exercise as directed above, the petitioners, the applicants shall be at liberty to mention the two writ petitions for its final disposal upon notice to the respondents.
You kindly give me this to amend the first issue.
What did I give you?
Already given. I will, I will.
Whatever you will have to do, you do it.
Notice
Then after completion of everything, give them notice.
to the board.
Notice to the board as well as upon them. And then mention, I will include them and pass the order.
Notice kindly fix any date. Notice
বুদ্ধি রাখে।
notice kindly.
Defective writ petition এ date fix করতে হবে। তো মহা মুশকিল।
I have.
বুদ্ধি রাখে, বুদ্ধি রাখে।
Tomorrow.
মহা মুশকিল। Unless your writ petition is regularized, how can I fix a date?
I will make necessary correction. You will also give me the
তবে এই রচনা হচ্ছে। Next, নেতাজিকে দিন উনি ছাড়বেন এই জাজমেন্টের
Great.
Ready for others, I will number 3 and 4.
ये यही कागज पे Yes. What happened? ঠিক আছে সে অত যাই না পেয়ে গেছেন ঠিক আছে পেয়েছেন তো আপনার প্রাপ্য পেয়েছেন
আমি 8 বছর ধরে পাইনি মাইলর এতদিন পর যে আমি পেলাম কলকাতা থেকে খুব আনন্দিত ভাবতে পারিনি এটা সম্ভব
কোথায় আপনার জন্য কোথায় স্টেটে সুমন দেশ
আমি ফোন করলাম
সে বলবে না দরকার নেই কোথাও please and ask him to come immediately. Matter is being taken up.
বলেছে আজ কয়েকবার Okay.
আপনি একটু ওয়েট করুন, যদি আসে আমি নিয়ে নেবো। আলাদা করে রাখুন। Please, madam, once inform him that after completion of that matter, he must come here. The court is making here, court will have to take up the matter. Down.
Next, item number 5. Five, application and reference to right. Compassionate appointment by your father.
I have rejected. So, give me that order. What do you want? No appeal preferred from that order?
What about your lordship?
No appeal preferred.
On the last occasion, it is a submission of Mr. Bharti that pensionary benefit cannot be calculated by assessing the financial distress. But at the same time, my point is that, and your lordship is getting that since the rules of the 2009 has not been challenged, so whatever is prescribed under the rule of 2009 shall apply.
These are reported or not?
I don't know. Please share it. But there is a judgment of Honorable Division Bench of presided over Justice Chattopadhyay, Honorable Justice Bota, that while calculating the financial distress, pensionary benefit should not take into account. But on that score, while none of the petitioner has challenged the rule, and as a result thereof rule prevails, and if the rule prevails has not been struck down, then the executive authority has compulsion to follow the rule as prescribed under the statute. And your lordship, after discussing the rule, and after that calculation, whatever calculation made by the comparing chart has done in accordance with the recent.
পারবো না, আসুন। This is the writ petition claiming compassionate appointment. Poster. In the identical paragraph, in the identical fact situation, the earlier writ petition was also dismissed. In the matter of Tanushree Mujumdar versus the state of West Bengal and others. Dated September 13, 2023, rendered in WPA 16525 of 2017. In view of the above, this court is also of the view that in view of the law discussed in the matter of Tanushree Mujumdar Supra, this court is also of the view that there is no infirmity and or nor any perversity in the impugned order dated
November 2, 2017.
November 2, 2017, passed by the respondent number 3. Poster. The said order passed by the respondent number 3 stands passed. Paragraph. This writ petition WPA 30024 of 2017, thus, stands dismissed, without any order of force. Poster. শুনুন, এটা একটা বের করে রাখুন তো, কম্পিউটার ভিডিও, a copy of the said
Man, I think on the last petition I ended one. See, five.
এটা দেখে লিখে রাখুন তো। আচ্ছা, a copy of the said judgment in the matter of Tanushree Mujumdar Supra is kept on record. Case before this court on behalf of the respondents is kept on record. এটাকে এখানে লিখে দিন, আর এটা দিদিকে দেখান তো, এটা লিখে রাখতে বলুন, আমার দেখিয়ে দেবে ফাইল আছে। পরে বলছি ওর জন্য না, আমি ঢুকিয়ে শেষ করে দিয়ে দেবেন।
Only difficult is that previous judgment of this court felt that the pensioner shall be taken care of, but none of the judgment is struck down the and in the case of the record, rule periods standardly executed.
But those are of division bench.
Now, one is division is decided over justice talked about the Indian WPST where there is a specific rule.
And what have I said on that here?
Well, that was not discussed. And that was not placed like this. Your lordship relied upon the judgment of the Supreme Court.
That to the effect?
To that effect, the patient, the compassionate appointment is the exceptions to the rules and
Is
the exceptions of the rule, and it is not yet any equity in favor of the claimant to acquire the employment. That point has to be discussed. Supreme Court.
আচ্ছা এইটা একটা নিয়েছেন কপি নিয়েছেন এই কপিটা না একটা নিয়ে ওই ফাইলে রাখুন আর আমাকে একটা দিয়ে দেবেন তো আমার একটা ম্যাটারে লাগবে So those single bench I have said that why I am disagreeing.
Well, no. Your lordship has not been considered the judgment of the honorable division
It was not placed. Right.
Even if it is placed before your lordship, that is passed in a WPST method order of the tribunal, where there is a specific rule not to calculate. Here in our rules, there is a specific rule discussing that how the financial distress has been calculated. In that course, your lordship.
And no appeal has been carried out.
Not in my knowledge.
No, otherwise they would also have to say that the appeal is pending or something. There also you appeared, madam, or it was from your that matter. Tolusri, in one matter you said that the CID has not been. You have given. Please give it today. Very good. So you can give us the 19 number also. Which way? Take the list. Can you do it now or afterward? I listed into okay. ওখান থেকে পেয়ে গেলে না সাহেব যেটা দেবেন নাম্বারটা পিটিশনে আমার জাজমেন্টটা প্রিন্ট আউট আমার জাজমেন্টটা অ্যাপিল করতে Yes, Daku. Where is Mr. Shuman Day? Fine.
The instruction I have not received. The instruction I was to take, I have not yet received. Just tell me not today. I'll
Pass over for the day.
give you a best.
Yes. Yes. Microphone loud. Report fine. Mr. Atish Kumar Vishwas, Learned Counsel appears for the petitioner, who submits that despite there being a direction dated of this court, dated December 4, 2023, the respondent numbers 1, 2, and 6 have not filed report as directed therein. Paragraph. Today also none appears for the respondents, nor any accommodation has been sought for. Paragraph. In view of the above, for the ends of justice, time to file report in the form of affidavit as directed on December 4, 2023 stands extended till January 22, 2024. Exception in the form of affidavit, if any, thereto shall be filed on or before January 30, 2024. The writ petition shall appear under the heading কিসে আছে? Forwarders on February 7, 2024. Paragraph. A copy of the learned advocate for the petitioner shall serve a copy of this order upon Mr. Bhaskar Prasad Boisho, learned additional government figure who appears in this matter.
Motion taken number 8.
देखिए आवाज दी आवाज दी। কোনটি পছন্দ হবে? এটা একই কোটের লাস্ট অর্ডারটা বা তার আগে অর্ডার কোন কোটের না দেখে দিতে হবে। আপনি দিতে বলুন তো কোনটা? ওনাকে বলুন দেখে আপনি গাইড করে দিন দেবেন। লাস্ট অর্ডার অ্যাপিল কোর্টের লাস্ট অর্ডারটা দিন। ইয়েস
Motion secondary item number 8.
none appears for the parties, nor any accommodation has been sought for. Motion secondary for dismissal on কবে দিয়েছি?
8.
হ্যাঁ
18.
18
9.
same
8.
same
11.
same
12.
same
Motion residency item number 13.
same শুধু হেডিং ঠিক থাকবে।
14.
This one next
15.
next same
Hearing assigned item number 16.
what is this?
Hearing assigned.
The assigned matters. No question. Proceed. Assigned matter to accommodation. On the prayer of Mr. Your name? Write down. Now, Mr. Such and such, learned advocate appearing for the petitioner submits that the arguing counsel, on the ground of Mr. Who is your arguing counsel? Vikas Shah. On the কি বললাম?
Mr.
Mr. Oni लिखे दे, give a name.
Advocate appealing for the petitioner submits that
Submit the paid for an accommodation, paid for adjournment on the ground of Mr. Vikas Shah and an arguing counsel for the petitioner, who is not in a position to proceed with the matter today. Yes, sir. Paragraph 1 appears for the respondents. Paragraph. Respondent. None appears secretary because Mr. Piyush Chaturvedi. And counsel appears for respondent numbers. Certain such. Paragraph. Rest of the respondents are not represented. Paragraph. In view of the above, the petition shall appear under the heading hearing assigned in the monthly list of February 2024. 5/2/29. Next.
Sometimes I don't taste the athletic abilities. Sometimes I don't taste athletic abilities.
Oh. Next.
petition number 50
देखिए ऑर्डर में कॉपी तो दिन 50
monthly list.
आरक्षण আছে 15 none appears for the parties nor any accommodation has been sought for the matter shall
for the mission director.
petitioner
50 monthly.
Yes.
none appears for the petitioner
Extortion application. Studies was followed.
none appears for the petitioner nor any accommodation has been sought for. Full stop. Mr. Sarwa Jahan, learned advocate, appears for respondent numbers. Blank. Paragraph. In view of the above, the matter shall appear under the heading application in the monthly list of March 2024.
Respondent number 2 and 3.
12. Thank you. Next.
16
15 minor.
monthly. March.
Next.
16
17 and 18.
15. Mr. Jahan is there.
Yes.
You are there.
Yes.
15. Crediting carefully. Restoration. Delay. How much?
600.
Only. So Jahan,
But I am not opposing the special application. But one thing I must suggest to my understanding that while filling up the affidavit portion, at least in case of restitution application, there must be
you must be.
process because whether the advocate on record was ill or not, that cannot be true to their knowledge.
Always. Or should.
Not may I take your words.
Can 2 of 2023. This is an application for condonation of delay for about 975 days in filing a restoration application. Full stop. upon perusal of the amendments made in the application and for the ends of justice, so that substantial justice shall not suffer for the procedural rigors. The delay stands condoned, subject to payment of cost of rupees 5,000 to be paid by the petitioner to the benevolent fund, Bar Association, High Court, Kolkata. Full stop. Paragraph. Subject to the above terms being fulfilled and upon production of the money receipt before money receipt to Mr. Sarwar Jahan, Learned Counsel, appearing for respondent numbers 2 and 3. The delay shall stand condoned. Paragraph. Subject to the above conditions, Can 2 of 2023 stands allowed. Paragraph. Can 1 for restoration.
Can
Can 1 of 2023. The restoration application shall appear under the heading application on January 10, 2024, subject to producing the money receipt for payment of costs.
Next week.
70, subject to production of the money receipt showing payment of cost as directed in Can 2 of 2023. ওটা 10 হবে না, 17 হবে। Yes.
to 18.
But I put it there are many applications. Yesterday,
For application for
different subsequent events and applications. Then the facts in the order. These petitioners are please.
let me see the prayer.
Yes.
Can
What?
file affidavit. No, I will not hear without affidavit.
So the main matter, take 1 minute. The main matter was filed. 3 institutions were filed by the school is governed by the special. At one point of time, the school had prayed for a minority status from the government. The concerned secretary of the government refused to grant that status. Challenging those orders, these petitions were filed. Reaction for affidavits were given to affidavits. These are pending since 2009. But very recent, order the bench of your lordship was taking up a similar file. Where my other side, they had pointed out these particular orders, that these orders have been passed, so the special rules cannot apply in that particular case. Here,
coordinate bench of your lordship here that no, that order could not have been passed. And here that executive order cannot operate and the rule will prevail, and in that particular case the ruling will in respect of the so taking cue of that matter, because the coordinate bench has already discussed and declared that, but in my humble submission, the point involved in the repetition has already been decided. So that is the subject matter, and because of this, the suffering of the school is such. Why I am submitting for your lordship?
Who is there on the other side?
But on the other side, Mr. Tonoy Chakraborty is there in two matters, and
Tonoy Chakraborty for state.
For state, and on his behalf, time was taken. So that is why
Who's there?
Mr. Chakraborty's behalf.
Ah.
And in the third matter, Mr. Ranjan Saha is there. I have given notice once again that today the matter will be taken.
Yes.
Mr. Tonoy Chakraborty, that's in photo number
Very well.
along
Acha. उन लोग क्यों appear?
while before weeks time and last year.
How many times you are asking this matter? One after another adjournment? Acha. Where is he? Very well. The court is waiting. Send it. Send for me.
This matter is such. These schools are having their own groups to appoint their own teachers and staff. Schools are having a huge number of students and lot of vacancies are there. They are unable to fill up those.
No, by subsequent development means you want to brought the records of
I
the
have
coordinate bench.
I have brought on record the coordinate bench judgment, and that judgment was carried in appeal. The appeal was dismissed at the instance of the other side. So the single bench judgment was confirmed. That I have brought, and I have brought notice of lordship in formalities carried out by the school for the purpose of recruitment. But that is pending with the government. Government is not taking steps because of the pendency of this matter.
Akshu. Who is there appearing? Who are there appearing?
One matter, Mr. Ranjan Saha is appearing. I given notice that will be taken up. And the other two matters, Mr. Chakraborty is appearing.
In all these three petitions, in the petition action order for application. The issues involved are identical. Oh, sir. Paragraph. From the order dated August 4, 2023, passed in WPA 18852 of 2019, it appears that Mr. ANIRUDDHA, learned government leader, appeared in the matter. Oh, sir. Paragraph. Previously, these petitions were called on several times when adjournments were sought for on behalf of the state, as submitted by Mr. Sandeep Kumar De, learned advocate appearing for the petitioner. Paragraph. Today also, none appears for the state. You are there briefed in this matter. Today also none appears for the state. Paragraph. It's application under the heading, appearing under the heading.
Application.
Good, sir. In view of the above, these matters, this series of matters shall once again appear under the heading application on Ajikautari January 16, 2024. Poster. It is made clear that in the event the respondents are not represented on that day, the court may proceed in their absence. Paragraph. In কি বললাম? Paragraph. A copy of this order shall be served at the office of the learned government leader. কিভাবে বলেছে অর্ডারটা শুরু করেছে বল? By the advocate and record for the petitioner.
In all these three cases, the issues involved are identical. Then upon the order dated August 4, 2023, passing document 1885 of 2019, it appears that Mr. Conrad Ray, running government leader, acted with the
ইয়ে করা দরকার, ঠিক আছে, নামটা বাদ দিয়ে লিখুন learned government leader. Learned government leader. হ্যাঁ। তারপর পড়ুন।
Previously, these petitions were called on several times when adjournments were sought for on behalf of the state.
Comma as
As submitted by Mr. Sundip Kumar, they learned advocate appearing for the petition. And they also null appears for the state. And in view of the above, these series of matters have once again appeared under the meeting application on January 16, 2024. It is made clear that in the event.
এই যে পরের paragraph। বাস ঠিক আছে। A copy of this order shall be placed before the learned government leader by the advocate and record for the petition.
We take lots of nuclear was just now in previous matters was referring on judgment delivered by your lordship. The lordship grants me very basic for reporting the compassionate appointment.
Please.
23 and 24.
These are all available on the server itself.
Yes.
Unless your lordship grants me, there are orders of reportable nature and non-reportable nature, so that is why I paid for your.
No. Yes. I'm coming for. Pass over. Every day this matter is being passed over. Every day. Who is the junior? Who is the junior there?
Number 23 is not become reactive. 24 is for 24. 24 will not have properties.
13385.
If you are the matter which
Proceed. Every day. Every day.
will not if we involve in this matter. This is related to a group report for a second.
But their presence is required.
This is here.
No, because if their presence is required, there is no point in hearing piecemeal.
PM Malad has a
No, no, I don't do that. I don't.
In fact, Malad on his week, time to time he heard the matter. Certain order was passed.
Where is he? And where is Mr. Shumande? Pass over for the day, tomorrow it will be taken off. Even if they are not there, what to do? We will proceed. Why you are not getting ready?
I'm not in this. I'm not in this matter.
You get ready. Tomorrow you have to come ready. Yes.
So this is mirror compassion at happened was rejected mirror citing mirror the schedule 5 of mirror the West Bengal selection of persons of
Calculation.
calculation and it said that financial hardship is not there since mirror the family mentioned it
Why should I entertain?
mirror three things mirror kindly comes to the mirror
এই অর্ডারটা দিন ফাইন্যান্সিয়াল হার্ডশিপের
yes
যেটা আজকে হলো আমার জাজমেন্টটা ছিল দেখালো ইউ ব্রট মাই জাজমেন্ট
sir I have collected it from the last mirror
তনুশ্রী বিশ্বাস go and read it. You say that this is not applied.
I hope that the division bench judgment decided over by justice for the petition was not cited.
না হলো আছে ওনার কাছে লিখে দিন
Yes, this is the last Miller gift.
then why not no appeal has been carried out? I don't know.
State petitioner. Bharat has
considered that it is in favor of the petition.
No, no,
No, this means.
this means you read the judgment, you have taken the number.
Yes, I have taken the number. I have taken the number and Malukta, what my learned is submitted regarding justice content with the division bench judgment. Malukta, that judgment, thereafter Malukta, on that judgment, a honorable Supreme Court decision has not been considered. Why Malukta contrary to was, which was prior to the Malukta judgment of the court.
So bring all those.
Yes, Malukta, I am getting.
Tomorrow, Pastor of the
Sorry,
No, this is not.
These are very material hard to look at.
Mr. Shumande is also not agreeing. One after another matters. No, then there's somebody here. One after another matters. Now the court is saying.
Half of the state of the I am engaging in this matter, I'll do.
In another matter, that the old lady has come, he's waiting. I've kept her waiting because of Mr. Shumande. Inform him. She's waiting.
That's right. It could be a management.
No. Why 2 p.m., sir? She is waiting. She has come all along. Her everything has been done. Since nothing is left out. But Mr. They has to file a report.
It's coming.
In another matter, series of state council in 3 writ petitions, none appeared. So I found the name of the learned government Peter in one of the order. I said that a copy of this order be placed before him so that he can come and appear tomorrow. None, nobody. What to do? What do I explain to before the petitioner? None.
That's what one is coming.
Then engage some more learned lawyer here. At least 4 or 5 learned state lawyers who will be here only. Engage at least 4 or 5 learned lawyers, they will be here only.
I am trying to. I am Dr. Advocate General, not for the GP. And then Advocate General, Advocate Proceedings.
Please. Yes, doctor.
Under item number 30, 39, 40, the judicial maker is taking part in another matters.
On the prayer of MS Sharvani Mukhopadhyay, he heading answer.
I motion higher secondary.
The writ petition shall appear under the heading motion higher secondary in the monthly list of March 2024. Paragraph none appears for the respondents. Paragraph or notice affidavit of service. Intimatary corpus 30, 38,
39, 40.
না কেস for the parties already accountable software for dismissal. কি হেডিং আছে? হ্যাঁ? For dismissal. Next. Next.
60.
60 IPL. After exchange of affidavits
Who is there for the state?
for the School Service Commission of the Pastorism.
And state, okay, school service commission is it. Proceed.
But I was seeking reassessment. I know whether there is an order
Ankur Manna.
of yes, of that they have disclosed that in the affidavit. But the law, as settled by the Honorable Supreme Court, is that if there is no provision banning reassessment, and place the disclaimer, then it is open to the writ court to order re-examination if there is a primary satisfaction for reassessment. Here there are 2 or 3 subsisting interim orders.
In the 2016?
The judgment I
No,
rely
no, selection,
selection is 2012.
not
During
SNST 2016.
Writ petition was filed in 2013. After I got the answer scripts through the RTI, there were series of interim orders kindly post to the order. There's a post which is reserved.
Interim order is neither
There's a
here nor
post
there.
which-
I'm hearing now the final.
Yes, there's a post which is kept vacant under an interim order. Though so the possibility of the selection being upset is not there. Because one post was kept vacant, because in the event the petition succeeded, she could be accommodated there. There's an interim order also that the model answers have to be produced. The division bench has directed those have to be preserved till the petition is disposed of. The model answers have not been produced, and now kindly so that highly sees this judgment of 2018 to SEC, which really settles the law that unless there is a specific provision banning re-examination, what should be the writ court's? This is 2018 to SEC 357. Para 30 is what I rely. 18 to SEC 357. So I have handed over to my lord SEC online.
Page
357.
And what about that judgment?
Paragraph 30.
Yes, one minute.
This is also a recruitment examination that the honorable judges of the Supreme Court were considering. Paragraph 30. I'm on 30.2. I do not see a prayer appeal to 30.3.
Yes.
And
Read out, Mr. Shumande. So it is extremely
My lord, item two zero
unsafe.
38, my lord. Just now, my lord, it finished and I am running up, my lord, and coming.
One after another matters.
Yes, my lord. That is continuing, my lord.
Please come.
My-
Yes, I will nominate the document. Wait, Mr. Chakravarti.
I was informed, but
लिखिए उठा लिखिए बोल।
I was informed, but I was.
Number 3 and
In other matters also, there are so many matters.
As my thesis, my lord, gets on the beach, my lord.
No, but how the court will also function?
My lord, I understand, my lord, my technology, but that's what my lord, I was not allowed to. Sort for a spot. Deep.
Yes, what is it? Where is your report? On the next day, the respondent number 4 shall file a short affidavit disclosing the said reasoned order dated October 11, 2023.
Then order. My lord, and I'm taking order, and the report has not been.
No question of report. You are directed to file a short
My lord, that
affidavit.
affidavit part, my lord. Reason order has been not handed over.
Mr. Dey, kindly see the order.
Yes.
October 2023.
That reason order has been.
But an affidavit has not been affirmed.
Affidavit, my lord, is like this kind of very sorry. It is totally my fault, my lord. And
Where is the reasoned order?
it's been, my lord, on the earlier.
You give me a copy.
It's been handed over, my lord. It's the. We have a.
You have reasoned order, madam.
Reason order. Commissioner आपने hello सही है सही
Though there was a previous direction by this court under an order dated October 11, 2023, to the effect that the respondent number 4 shall file a short affidavit disclosing the reasoned order dated October 11, 2023. It is unfortunate that even today, the direction has not been complied with. Poster. The writ petitioner appears in person. Poster. She places a copy of the reasoned order dated October 11, 2023. Comma. The same is taken on record. Paragraph. The petitioner further submits that she has received all her employment benefits as directed by this court. Whatever she is eligible to receive in law. She has confirmed that she has no further claim in this writ petition. Full stop. Paragraph. She only prayed for interest on account of delayed payment. Paragraph. This court is not inclined in the fact situation of this case to grant any interest in exercising its equitable jurisdiction. Full stop. Paragraph. The petitioner has already received her claim in entirety. Paragraph. In view of the above, nothing further survives in this writ petition. Full stop. Accordingly, this writ petition WPA 6283 of 2017 stands disposed of, comma, without any order as to cost. Interest আমি নিতে পারবো না। কি আছে এটা? দুটো। So both the writ petitions, আর আপনার কিছু বলার নেই, দুটো writ petition শেষ হয়ে গেল। হ্যাঁ,
যে গ্র্যাচুইটিটা পেয়েছিলাম ডিলেতে, সেই গ্র্যাচুইটির ইন্টারেস্টটা 10 মাসের পর এইটা ইন্টারেস্টটা গ্র্যাচুইটি।
না কি বললাম, ইন্টারেস্ট কি বলেছি?
For that petitioner is entitled to get interest for delay payment of gratuity from 30/9/15 to 17/8/16.
The petitioner for the service that she has received all her employment benefits as directed by the state, whatever she is eligible to law. She has no claim
in both these writ petitions. Both these writ petitions.
She only paid for interest on account of
delayed payment. Okay, cartoon. She only claims she claims interest on delayed payment of gratuity. She further claims only the interest. She further claims only the interest on the delayed payment of gratuity. Since
30/9/15
September 30, 2015 till the date of actual payment.
17/8/16.
Till the date of actual payment being
17/8/16.
August 17, 2016. Paragraph.
My lord. My lord.
this court is not inclined.
No, ওটা এখন লিখবেন না, কেটে দিন। এবারে Yes.
My lord, এটা স্যালারি এটা যদি করে টাকাটা দিল না একটুখানি ইন্টারেস্ট
Interest on gratuity.
না এটা তো ওই যে স্যালারি হবে না
So, sir, she further claims interest on the delayed payment of arrear salary. Full stop. This court finds no reason to grant interest on the delayed payment of salary, on the delayed payment of salary. Full stop. Further. However, petitioner shall be at liberty to make a representation before the respondent number, delayed payment, into gratuity. Respondent number before the jurisdictional district inspector of school. Which Bardhaman? Posting Bardhaman. কি বললাম?
However, petitioner shall get liberty to make it potential before
Posting Bardhaman. Claiming interest on delayed payment of gratuity.
payment of gratuity
Key, which one?
বলতেন আসানসোল
না পূর্ব বর্ধমানে
District jurisdictional district inspector of school, comma Asansol. Asansol. Bardhaman পেড়ে দেবেন। তা কি লিখলেন?
claiming interest on delayed payment of debt.
Claiming
However, petitioner shall get liberty to make a representation before Asansol, claiming interest on delayed payment of debt.
full stop. In the event such an representation is made, the jurisdictional district inspector of school shall deal with and dispose of with reasons strictly in accordance with law. Full stop. Accordance with law, positively within a period of 3 weeks from the date of receiving such representation. Further, with the above observation, these two repetitions stand. These two repetitions, being WPA blank of land and WPA blank of land, stand disposed of without any order as to cost. Next.
monthly list. Number 60.
That being the law, then I submit that
Any house to be?
I was referring to paragraph 30. That's good.
Show me that it is the rarest of the rare cases.
At the interim stage, again, there is some people.
No question of interim is
Because
much.
prima facie satisfaction.
Prima facie is a tentative view.
Yes, that was why the people.
You show me that you squarely fall within.
Yes.
30.2.
That is, I say my duty to do.
You have read my Ankur Manna judgment.
I have been privileged to read the judgment that was next in the writ petition. But I'm sure this judgment of 2016 was not placed before my lord.
Of course, it was placed.
But
2018.
Yes, the one I said.
Yes,
But this is Montu.
That I don't remember. You have carrying Ankur Manna.
No, I'm carrying Montu, which is a school service commission matter.
You consider my Ankur Manna as well. Proposition of law is the same.
Proposition of law is as stated there that I have to satisfy to the rich court.
You show me You satisfy me on 30.2.
Kindly, Malad, I'll compare the answers that I have given to the.
You should first satisfy
That is the exercise that I am willing to embark.
Kindly take.
Rarest of rare cases, my lord has to be satisfied.
Kindly take 30.3.
I am not requesting my lord to carry out the review.
So where will be the utility by seeing the answers?
First purpose would be served if the model answers which the division bench had directed to be preserved are called for. Even a cursory comparison with that, with the answers that I have disclosed, would reveal whether I have any case at all.
You read 30.2, then you satisfy me. It is such a case.
That satisfaction is not possible unless the model answers are produced.
30.2.
Yes.
Madam, continue. Then it will be, the matter will be.
Unless the model answers are produced as directed earlier and as confirmed by the Honorable Division Bench, that exercise cannot be carried out. I can only make the comparison with the textbooks that were recommended and the answers that were given by me. I got the answers from the RTI. Otherwise, what does my lord have in mind? How will I be able to process that? Unless the writ court permits me to embark on that exercise.
You are carrying the judgment? No question of adjournment. You proceed. You are carrying the judgment.
In their affidavit, they have disclosed this judgment of my lord.
Let me see.
If it is a reported judgment, I can come back,
That I don't know whether reported or not.
Then,
where is the affidavit in opposition? Give me the report. You very well, you give your copy.
Here, the judgment cited is by the commission. This is my lord's judgment. This is the same facts, similar thing, but there the exercise was not even attempted to be done.
Any appeal carried out? Muntu?
But here, Malad, this 2018 2 SCC was not cited.
Doesn't matter. I have held in the same line.
But my lord has to permit me to demonstrate.
If you see, I have held in the same line. Considering the relief claimed in the writ petition quoted above, this court is of the firm view that in absence of any specific statutory provision or rules, this court cannot direct review or reassessment or evaluation of the answer script of the petition. As much as today in 2023, since today in 2023, since the relevant selection process has concluded long back in 2015, no cause exists as to why this court shall intervene in the selection process of our.
Yeah, my case is different because in my case there is a vacancy which is kept.
That may be.
That the selection process will not be jeopardized in any manner. So, if I have to satisfy my lord that I come within the purview of 30.2, my lord has to permit me to demonstrate from a comparison of the answers that I have given. My lord will permit me to carry out that.
Then will I not be hit by 30.3?
30.3. I am seeking a re-examination order from.
I am not the expert.
My lord will refer it to the experts. That is the purpose of 30.2. And the safeguard is 30.3. If there is a prima facie satisfaction that the answers that I have given are either tallying with the model answers which they have been directed to produce,
Will not brush aside the earlier entry models.
Don't get 24.
That would have been not meaningful, my lords. I
I
wish
will find
had
it
they
as-
not
That's what I'm telling you, five years.
they sought time yesterday. But had there not been such an injury model which protects me, kindly permits me to demonstrate. Otherwise, how can I? Yes. Well, kindly opens my mouth free. In the absence of answers, which the division bench directed them to be produced and, if necessary, called for. The single bench has also directed the model answers, which is called the key answers here.
What's the extent?
But our stand is that the writ application, the allegations are vague. They have not specified any particular question against whom they are having allegation. They have not even demonstrated what will be the correct answer as per the petitioner lordship.
That is, I with utmost respect.
Wait then.
And I would am protected by lordship's order in a matter.
Montu Mondo.
Yes, your lordship. And
What
there is
about
no- there is
Unkur
no
Manna?
provision for any
Unkur Manna.
Since
and there is no provision for any
SFC, that will be more apt because this is an
We also consider Onkur Manna. Take down Onkur Manna. Proposition of law is safe.
I have to cross the hurdle of 30.2. And I'm sure my lord will permit me to embark on that.
Yes,
But this submission made by my learned friend.
Which one which you want to?
I wish first, my lord, to place page 68 where I have given a table, unlike what my
Show me from what is the case made out in the writ petition.
Case made out is summarized in page 68, a table in tabular statement.
No, from your pleading.
From your
writ petition.
That the answers I have given are.
Show me the relevant paragraphs. Why are you shying away? Show me. What is the case you have made out in the writ petition?
Kindly see paragraph 13 and page 8. And this I have demonstrated by reference to extract from the textbooks which I have annexed.
13.
Yes.
Yes. Place it. Place it.
Basically, read it. I am reading.
Yes.
On a careful perusal of the answer script, your petitioner found that the answer script had been assessed in a highly perfunctory manner, without application of mind, and as a result, she has been awarded 0 even for questions correctly answered by her, especially in the zoology. This will be clear from a comparison of the answers written by your petitioner with relevant pages of widely read textbook. Xerox copies of whereof are annexed here to and collectively marked Annexure P6. A statement giving particulars of the books relied upon by your petitioner and relevant pages thereof to support her claim. The answer script is also annexed via RTI disclosure. To support her claim that she has not been given marks she is entitled to even for correct answers of specific questions is annexed here to and marked Annexure P7. This is the summary and the comparison of the answers and the textbooks as summarized in that table at page 68 is all I can do. And if they have produced the model answers in terms of earlier direction, I am sure my lord would have been assisted in my lord's attempt to see one easy thing, relatively easy. If
Sir, 10 reference book you have referred.
Each for one specific question.
I don't mind.
For each particular question, one.
Very well. Let's say for one question, there are 5 references.
That is why the model answers. That would have abridged the exercise. Why are they falling shy of producing the model answer? More so, if there is a direction of the rich court and confirmed by the government.
Show me that direction.
That is in my lord's file, also the 21st October 2013 order.
You have filed affidavit in opposition.
Yes, you got to be steady and family.
5 minutes of long pass.
21st October 2013. And the Honorable Division Bench has said those answers, model answers have to be preserved.
1st October
2013.
Yes. What happened to the division bench?
Division Bench said that model answers have to be
Where?
preserved. There is the file. That
It cannot be. Division bench order, how can it be this?
have handed over a copy. Again, this is another copy.
All right.
At page
1st of December.
page 2 of the order. The
1st of December.
yes,
1st
the
December.
second page. I prayed for before the division bench that the declaration be heard out without affidavits. The Honorable Division Bench had declined that.
এই পাখাটা চালাতে বলুন তো এসি চলছে নাকি
হ্যাঁ এসি চলছে
হ্যাঁ
চলছে
কোথায় এসি চলছে দেখ পাখাটা চালাবো
Lordship, may I take over this matter since your lordship by mistake some other people has come.
That's the second page, the fourth last paragraph.
Yes, what is the significance of the appellate court order?
Appellate court order is that if after affidavits the rich court felt it was necessary, it will be produced, and if you safeguard that, the model answers were directed to be preserved.
Then
nothing more. I didn't want to seek any other direction from the appellate court.
Very well.
I had sought that the writ petition be disposed of without affidavits.
Then where is the preservation of that single seat?
Is page 2. The paragraph.
No, that is the preservation of the model answer. You said that one seat is kept.
That is the order dated 24th October 2013.
Single bench.
Which was continued in the disposal of the writ petition by 21st November. The 21st November, that was directed to be continued. So this issue of unsettling the selection process at this stage after a decade, that with respect cannot happen.
Yes, Dr. Bhatta, very good affidavit.
The brief has not, some other brief came by mistake, so like the judge's copy has not been filed.
Few matters, nobody appeared for School Service Commission. Previous matters, there are at least 2 or 3.
We'll have to check who is engaged because whole matter, most of the matters were with other advocates and.
And what is your stand on this matter?
Our basic stand in this matter is that since the rules do not provide for re-evaluation, and we have taken a resolution also with regard to re-examination, that it will not be permitted. So the question of reopening the chapter with regard to the petitioner's grievance for rechecking of the OMR.
But if there is some glaring error, that
no, the glaring error has not been also indicated in the petition. No. Normally, what we find is in any matter.
Very well, but the division up to division bench, the model answers are directed to be preserved.
That is not difficult. That the model answers, whatever we have.
So model answer comparing with these answer state, what is your stand?
That I have to check because in our affidavit we have not dealt with that. The aspect which we have dealt with is 2 things. Number 1, in the petition, you have not laid out a specific case.
And those are all on technical issues, but on core issue, what do you say? Then you should have come up with this. You should have.
No, this is not a technical issue. The petitioner, what we normally find in, say, hundreds of petitions which we are facing, that if a petitioner really thinks that he has written the correct answer, then he comes up with the books as addictions to demonstrate it first.
Dr. Patro, this petition has traveled a lot of its way. Right? Interim orders are there, division bench is there, even 1 seat is secured, I am told. So then why not this comparison or the report should come disclosing your model answer and the answer of the answer key?
Very well, let us come back tomorrow. I try to satisfy.
Because in this case, lot of path has been traveled up to division bench.
No, the petitioner, he can travel to any court to any extent.
No, but the division bench observations are there. First, to be preserved, the model answer to be preserved. What for? Definitely for some reason. Second, 1 seat is kept segregated. What for? Definitely for some reason.
The direction subject to, this is how I would visualize it. The division bench would tell me to preserve things, not because the petitioner has necessarily made out a very good case. The direction for preservation is that in case the petitioner succeeds, then his relief should not be held back because I destroyed
the core dispute is that the petitioner says, I answered correct answer. please produce the model answer and then compare. That is the code division. To that division will preserve the model answers.
And
To
given
that the
particulars of the
division
question.
makes, to that the division makes,
Question particulars.
to
No,
that
let me come back to model because I will cite one.
The model answers we produce, will a copy be handed over? I can assist my lord. If I don't have a case, I don't have a case. Why should this be extended further? My lord's precious time also, and this petition is adding also. Let the copy of the model answer be furnished. I give it to my client, she sees, she is satisfied, I withdraw.
come tomorrow.
I have certain specific questions which I have enumerated in that table, and I have demonstrated by annexing the extracts of the textbooks, naturally not the entire textbook.
You consider one of my other judgment also Ankur Manna.
And also one of this 2018 SCC.
No, that is the Ranvijay Singh. You also consider Ranvijay Singh he is relying upon. 2018 to SCC 357. 2018 to 357.
So kindly permits me to file the reply.
On the prayer of Mr. Ramji Chatterjee, Granite Council appealing for the petitioner, time to file affidavit in replies and extended till today. Full stop. The affidavit in reply filed in court today is taken on record. Copy has been served.
Yes.
Copy has been served upon N.S. Shukriya Dubey, learned advocate on record for the School Service Commission.
To find out
আজকে ছেড়ে অর্ডার লিখতেই যাবে না, এটা রেখে ফেরত দিয়ে দিন। নো নো, কালকে আসুক। You take it back also.
Let the model answers be kept with the learned counsel for their terms. So we need not come back again.
হ্যাঁ
Under reading review application, item number 1.
What do you say about delay?
No, usually I do not say anything, but in respect of review, I have to say.
Of course, that's a merit. Ashok. To review technique. Ashok. In rate can 1 of 2020 is an application for consultation of delay for about 389 days in preparing the review application, seeking review of an order dated June 10, 2021. It's paragraph. Mr. Devaki Shud, Learned Counsel, appeals for the petitioner. Paragraph. Mr. Otharup Banerjee, Learned Counsel, appears for the respondent. All the respondents. Paragraph. Considering the amendments made in the application for condonation of delays, the court is of the view that sufficient cause has been made out as to why the review applicant could not find the review application within the time. The law is well settled that for procedural latches, substantive justice should not suffer. Paragraph. In view of the above, and for the ends of justice, this application, the delay stands condoned. Paragraph. Accordingly, bold can 1 of 2023 stands allowed. Paragraph. Ever RV in Ray RVW 176 of 2022. Tell me, give me a date.
That is one of the cases where the petitioner is driving. Allegation is he lost for the date 30th.
Tell me one day
Watch
when you will be coming, both of you.
Anything subject to your system.
You wish to file any affidavit in the review application?
But subject to within 2 weeks. Yes. Within 2 weeks. 2 weeks.
2 plus 2. Yes. To expedite the review application by consent of the parties. The review application has also been taken up to date. Paragraph. On the prayer of the respondents, time to file the affidavit in opposition shall be filed on or before. Give me a date. Give me a date. You give us a date.
By 29th. By 29th, not by 20.
January 29, 2024. Paragraph reply, comma, if any, comma, thereto shall be filed on or before February 8, 2024. Give me a date. Give us a date subject to our convenience. Come on. Give us.
15th February or 14th February. After Saraswati Puja, that is my mother 21st or 21st. 2021st.
20?
21st.
Yeah, let us start. Yes, subject to my logs.
My 29th is my retirement, 90 is retired. But it took me my lord second week of February, that is my 13, maybe 13, 13 or 13 holiday.
February holiday.
13 holiday.
February 12.
My lord,
কি বললো?
Reply thereto shall be filed on or before February 8th.
Paragraph. The review application shall appear under the heading quote unquote review application review on February 12th, 2024 as agreed by the parties. We are review
To expedite the review application by consent of the parties, the review application has also been taken up today itself. On the prayer of the respondents, the affidavit in opposition shall be
must
filed.
contain other. এসে গেছে আর কি দরকার আচ্ছা মাথার উপর লিখে দিন affidavit of service একদম ওটা লিখুন condemnation এর মাথায় wait affidavit of service filed in court today is taken up so sorry ওটা পড়ে কি তাহলে ওইটা একটু ম্যাডাম লিখলেন under the heading
Application shall appear under the heading registration of February 12, 2024 as
mark that
stated by the
as agreed by the law mark that to be as agreed by the parties mark that to be.
Matter, aside matter, item number 1 and 2. This is the Hanuman cotton mills limited and other transaction from Himalayan. Amazon will take further addressing your lordship with transportation. Now, the first issue which I will address your lordship on is whether issue relating to the
1 minute sir.
Yes.
Yes, we are on in FMA APO 210.
210.
At the last order from I said,
See, question number 2.
yes,
Milord, before Milord, I go into Milord the judgment. I just Milord structure my submissions in Milord 3.
do in your own way. No, no problem.
First, Milord, I'll address your lordship on whether a question of law, what is a question of law on which Milord the appeal is permitted to be examined on. But what is perversity question of law? And then Milord, I'll proceed to address your lordship on whether Milord interpretation of a document can result in a question of law being raised, because that is fundamental to the submission. That's Milord.
And another question which is now coming to my mind after hearing your submission, that whether interpretation of a document can be done. If so, to what extent in 397?
Yes,
In 397.
in 397. Yes, so in fact, the judgment I'll address your lordship later on that, but the judgment which I will cite will not cover this also. But interpretation of document, etc. Then, Milord, I'll give your lordship, Milord, a very brief background of the situation in the family, all on the basis of admitted facts and on the basis of the judgment. Because finding of fact, really, there is not much of incorrectness in the judgment. It's only, Milord, the perversity of the ultimate finding. And then, Milord, I'll take your lordship to the
Application of law. Perversity, square application of law.
Milord, to really come to the point, there are, Milord, two principal perversities. Milord, as your lordship knows, section 397 code is required to adjudicate and end matters complained of. Not Milord reopen the matter or leave it, Milord, for the next 5 generations to continue litigating. In this case, Milord, admitted position number 1 is there is a family settlement. Admitted position number 2 is that the two brothers, Milord, separated. Milord, I am Ramesh, he is Mahesh. Milord, Ramesh and Mahesh separated is Milord admitted. My case is the separation is qua ownership. His case is the separation is qua management. So, Milord, the fact that separation has happened is Milord admitted. Next issue is father. His case is that father and mother remained. My case is father and mother went out also. In consideration of us brothers taking care of their liabilities. Now, for the moment, Milord, I just give the analyze the judgment in 2 sentences. In the judgment, the learned judge, Milord, has held that you and your brother have separated. There is no dispute regarding that. But this is not separation of ownership. This is separation of management. Because you can't have anything to do with his business, he can't have anything to do with your business, to the extent that his transfer of shares in my company to me has been upheld. He challenged it. He had 1025 shares, which he transferred to me. That's been upheld. He challenged it, that was rejected on the ground that this was my company. He would have had nothing to do with it. So, Milord, the principal infirmity in the judgment is that if you say that there is separation, if you hold that this is complete separation and no involvement at all, then I humbly ask myself the question, why would the learned judge, Milord, are not Milord hold that his wife also had to transfer her shares to, and that he would not have any form of Milord interference in my company. And the judge would have also appreciated that father, by using the same logic, if this was my company, even for management, then father and mother's shares would also come to me because their liabilities are taken care of. So if you say that this is separate but only for management, and yet you hold that you don't have that Mr. Mitsu's client has no right in his shares. Those shares have to come to me, and they have come to me. Once you say management include the right to take over his shares, as a corollary, Milord, what happens is that I not immediately get a right to his shares, his wife's shares, father's shares, mother's shares, because it can't be given to anybody else because it's come to me. So this situation, Milord, should have been appreciated, and the learned judge, Milord, should have put an end to the matters complained of, as was our section 402 language, which we used to plead in the petition, to put an end to matters complained of. You don't do that. The learned judge, Milord, says that yes, it's my company, brother has no role, brother can't come in, his transfer of shares to me is upheld, but he puts father squarely in control of the company with me. His father is, Milord, a signatory to the going to be a signatory to the bank account, father's removal is bad, etc. etc. Now that's Milord going completely contrary to the family settlement.
So who is the other appellant? Father?
Father is now no more. Now, Milord, it's a very strange situation.
So how could he acquire right from father's portion of right?
So what he has done is, he's Milord propounded a will. I am Milord opposing probate. It's in this honorable court I am cross-examining him. Milord, but let's assume, Milord, that the will is probated. Going by the logic in the judgment, even if he gets father's and mother's shares, that will also have to come to me. He'll have to give them to me because it's mine.
No. If the will is probated,
yes,
as he claims,
yes,
in terms of the will, then whatever the provisions in their will, that will have to be upheld.
yes,
Whatever provision.
yes. So,
it may go to a street child, it may go equally, it may go whatever way.
Correct. But, Milord, probate court is never going to decide, Milord, the underlying agreement between the parties.
No.
The underlying
Probate
agreement
court will simply look at the will and give a rubber stamp.
that it was duly executed. Even with the due execution, the underlying agreement between father and Milord us, which is recorded in the family settlement, will not remain. The underlying agreement is that foundry is me. So even if you get it, you have to give it to me. Your shares you have already given me. So any further shares which you get, you'll also give me. I don't have any right in machine. So the learned judge Milord did not.
Then what you are saying, if in terms of the probate, you as such under the agreement you get the foundry unit.
Yes.
He gets the cotton mill.
Machine.
Oh, cotton mill is also.
Cotton is part of foundry.
Okay.
Cotton mill, Milord, is the owner of the foundry of the land, and Milord, the other company is the lessee which owns the factory.
So, if under the will he gets part of the, let's say, foundry, under the, let's say, under the will. But the agreement says total foundry will come to you.
Yes.
Foundry in total will come to you. Then which shall prevail?
Agreement.
The probated will.
To probate code doesn't decide title.
Absolutely.
So probate
But the
code.
will probate, the moment probate code gives a rubber stamp to the will,
Yes.
that will is genuine.
Correct.
So the will has to be executed in its true sense, spirit,
Absolutely.
and terms.
Now, what will happen
Now,
is.
if under the will,
Yes.
part of foundry goes to him.
Yes. That will be contrary to the agreement. So
Which will
agreement will
prevail?
prevent. Agreement will prevent him from claiming rights which is contrary thereto.
Agreement is between the two parties.
There is a contract.
Agreement is a contract.
3%.
Whatever, between
Yes.
the parties.
Yes.
Contract, agreement is a contract restricted to the parties to it.
Correct.
But the moment probate comes, it's enread.
Yes. He'll get title. Under in view of the provisions of the will, father's shares which are in father's name will have to be transmitted to him in terms of the probate. But the second he gets those shares, I would have a claim.
No, you are saying it might happen that the entire a part of the foundry will go to him under the probate. But the moment then you execute the agreement, then he has to transfer.
You have to give it back to me, because the father would not or could not act in breach of his obligations under the agreement. The father's already agreed that foundry is me, machine is him. So, my lord, this act on the part of the father in giving him the shares, would ultimately not hold good when it is judged on the touchstone of the agreement. So, what all that I am trying to see, the hypothetical situation, when he would have to succeed in probate, I would have to fail in probate, I would later have to ensure that this contractual right which I have is enforced against him. So all that is hypothesis only. But what I am on, is that the learned judge, after appreciating this, should have, to put an end to matters complained of, under section 402, directed a solution. Should have either said that everything, like the way his shares have been given to me, should have also directed the remaining shares to me, should have declared him to be having zero rights, should have held that father has only, even if it was held that he had managerial rights. Firstly, I would submit that he did not have, but even if it was held that he did have managerial rights, then that should have also been construed. In short, to put an end to the matters complained of, what was necessary is he was required to be, Manish Kejriwal was required to be excluded from the company for all purposes, present and future.
From the foundry.
Which hasn't been done. So that is a serious jurisdictional error on the part of the judge. So there are many ways to do it. Depends on the interpretation. But the end was
the result will be
one net result. Foundry is mine. You can't come and interfere. And that was necessary, my lord. If your lordship looks at the history of this case from the date of the judgment till today, it's been only interference. He's writing letters to pollution control board, getting my lord my licenses cancelled. He's my lord writing letters to banks. He's creating trouble by obtaining status quo orders.
You are Ramesh.
I'm Ramesh. He's had half my factory dismantled. We're constantly fighting. So this is, my lord, what is to be, my lord, finished. The method, the manner, and the terms was the domain of the company law board. That is the jurisdiction, and that is, my lord, abdication of functions. That ought to have been done, but has not been done.
Now, my lord, I'll give your lordship a brief, my lord, 5-point background, all of which, my lord, emerges from the judgment. 1996 is the first date. 2002 is the last date. So 6 years is very important. 1996, there is a tentative oral family settlement. That's the case which is pleaded. A tentative oral family settlement is below contemplated, discussed, reached, and is under process of finalization. It's not final. It's not conclusive. It's tentative. But parties will start acting in terms of this. Admitted possession, and I'll show these documents. Mahesh, that's Mr. Mitro's client, leaves the company in 1996 and he takes over machine. March 17th, 1997, Mahesh forms a company called Parijat Vyapar Private Limited. This is his flagship company and he forms it in March 1998. Mahesh transfers 1025 shares in the company held by him to me. 1025 is a good serious number. It is almost 1/7 of the total share capital. 7,000 is the total share capital. 1025 he transfers to me. 1998. Same year, my lord, Hanuman Foundry, which is the company which owns the factory, goes into BIFR. Vaisa Bank files a OA and starts recovery proceeding against Hanuman Foundry. 1999, mother had cancer and father withdrew. This is his statement. Show your lordship the fact. Father withdrew from all businesses to look after mother. Unfortunately, never came back to any of the businesses again. That's 99. Between 96 and 2002, all machines which were not there in 3-4 partnership firms, etc., all of them were transferred to Parijat Vyapar, his company, and Millard, his firms. So the
machines
of there were two divisions, the machine division and the foundry division.
Okay. So the from the mother corpus, it was transferred to Parijat.
To Parijat and his firms. Millard, these are all those heavy earth moving machines, excavators, tippers, loaders. Millard, for mining, lordship knows magma business, mining contracts, etc. So large business. In fact, that is a larger business. And I'll show that in the course of my submissions that machines were worth more. Foundry was floundering. Foundry was in fact shut off. The foundry, I forgot to note the date. I think in 2001, the foundry was under lockdown. This was the situation. We tentatively agreed, I'll have foundry, you'll have machine. You went out of foundry and you took the machines. You made your own company, you took over the firm. So you took over machines completely. I took over foundry. Father stopped coming to any of it. Father was looking after mother. In this situation, on the 29th of September 2002 came the family settlement. I will read the family settlement. But before that, I would humbly pray that your Lordship looks at page 535 of volume 1.
What is that, sir?
That is, my Lord, Dr. V.K. Kejriwal's affidavit.
Volume 1.
Page 535.
Who is VK Kejriwal?
Uncle. Father's brother who stayed with the family. No children.
He is also party. He's leader.
He signed the family settlement. He attested it, but he has no share.
No, but is he a party to the proceeding?
Not much. He swore an affidavit.
Dr.
Vijay Kumar Kejriwal.
Yes.
Now, this is much later. He found an affidavit indicating the circumstances in which the family settlement came about. That paragraph 535, third paragraph, my answer.
Dr. Volume
1.
Read.
The page 535, paragraph 2. Since I am a medical practitioner, save the common residents, I have no interest of any kind in Sri Murari Mohan Kejriwal or his family's business or properties. My sister-in-law, late Savitri Devi Kejriwal, wife of Murari Mohan Kejriwal, passed away in 2004, leaving behind her husband, her 2 sons, and her daughter. Daughters will not incidentally said that I don't want anything. Leave me out of the trouble. During the lifetime of late Savitri Devi Kejriwal, certain disputes and differences arose between her sons, namely Ramesh Kumar Kejriwal and Sri Mahesh Kejriwal. She was then suffering from cancer and could not tolerate the internal friction in her household. With a view to permanently settle such differences, paragraph 4 at page 536. With a view to permanently settle such differences during her lifetime, she asked her husband, her sons, and myself to partition the family properties equally between her sons so that each one could focus their attention to develop their own businesses without any expense or obstacle from the other. Accordingly, after a detailed and comprehensive discussion, the family properties were partitioned among Sri Ramesh Kumar Kejriwal and Sri Mahesh Kumar Kejriwal via a memorandum of settlement dated 22nd September 2002. A copy of the memorandum said memorandum was typed by Mahesh Kejriwal, checked by Murari Mohan Kejriwal by pen, and signed by all four parties. Murali Kejriwal, the father, Ramesh, Mahesh, and myself. The family's properties and businesses were divided into two broad divisions, foundry division and machinery division. Sri Ramesh Kejriwal chose to take the foundry division, which he had been managing so far, and Sri Mahesh Kejriwal chose the machinery division, which he had been looking after. Both the brothers, Ramesh and Mahesh, have been given complete authority over their respective divisions and were entitled to deal with the same independently as absolute owners without any sort of hindrance or obstruction from the other, with a categorically mentioned right to sell their properties. At the instance of Sri Mahesh Kejriwal, who was apprehensive of his personal guarantees and liability on account of the foundry division loan, it was decided that Sri Ramesh Kumar Kejriwal would do the needful documentation and legal paperwork for Mahesh Kejriwal's complete withdrawal resignation from the foundry division. However, since the residence office and good on mortgage with Indian Bank and Punjab National Bank and could not be partitioned separated immediately, the present arrangement of the same was decided to continue until the liability of such banks are fully repaid. Till such time, an interim arrangement between Ramesh Kejriwal and Mahesh Kejriwal to share all common expenses on equal ratio was agreed upon. After liquidation, this is really household. After liquidation of such liabilities, the total properties would be partitioned and the interim arrangement would cease to exist. Inasmuch as Sri Mahesh Kejriwal desperately trying to rescind the above mentioned concluded contract, aided and abetted by outside elements with ulterior motive, it became necessary for me, one of the signatories of the memorandum, to make this affidavit for clarifying the position precisely, with a view to remove any misgivings in the minds of Ramesh and Mahesh. In view of a clear-cut division and family partition of the properties between Sri Ramesh and Mahesh, as more fully enumerated in the family settlement, it is not open to either party to take a contrary plea thereto at this stage. If I may use the expression, it's a very fair affidavit which discloses, Milord, even though the concerned gentleman, Milord, stays with me, as expected from a medical practitioner. It's a very fair affidavit and discloses the parties and what, Milord, they had agreed. Now, Milord, on the next page is the family settlement. Your Lordship has also seen this document and perhaps marked it elsewhere.
Doesn't matter.
Now, Milord, with this background, I want to, Milord, indicate 3 or 4 bullet points, which is the intention behind the settlement or what it achieves. Point number 1. This is 2002 from 96, when this germ of an idea of separation first came into the minds of the family. I have machine, I have foundry, he's got machine, and we are independently looking after this. B. Machine is doing well, its value is much more than foundry. C. Foundry is shut. By 2002, foundry is shut. B. There is a liability on the foundry. There is a mortgage in favor of Indian Bank and Punjab National Bank, which is recorded here. Then Vaisya Bank has filed proceedings against foundry. Everybody is involved. For these liabilities, grandfather is or not the father is also in. He's a guarantee. And in this situation comes the family settlement. Very logical, Miller. He gets what he's been managing, I get what I have been managing. Father gets nothing apart from an indemnity from us brothers to hold him harmless. So, without condition of, one would think that I have everything. I give up to my sons, I relinquish. No, I would submit. No, this is not relinquishment. It's like a tea garden today when the tea industry is down. I can buy a tea garden for 80 lakhs, the price of a flat in South Calcutta. But to run a tea garden, I need to be able to make an operational loss of 5 crores. Apart from the investment which I am taking out. So I need 15 crores to run a tea garden. 10 crores I will pump into the tea garden and I'll get it out from the sale of green leaves. And 5 crores will be my loss till I can turn it around. So the actual price, and I need 3 years to turn around the tea garden. So my actual price for the tea garden is the 80 lakhs plus the 5 and the 5 and the 5 crores of operational losses for 3 years. 15 crores plus the interest on the 10 crores which I am pumping in every year to keep it functional. So it's almost 20 odd crores. Like that, here apparently, but 2002 was an uncertain time. In 2002, Foundry was under threat. There was an OA. There was threat of SAPVC. What father achieves is total indemnity. I don't have to worry about anything. I will not be held liable anywhere. And you will ensure, both sons will ensure that my liability is not there. So, effectively, he gets in crores because money was due in crores to the banks. He's liable for that money. So that whole money, 1/3 of it, he doesn't have to pay any further. Now, please see clause 1 of the family settlement. 29 September 2002 family settlement. Present MM Kejriwal, VK Kejriwal, RK Kejriwal, and MK Kejriwal. The foundry work will be looked after by RKK independently, and he will be owning and accepting all liabilities of the same. Make proper admissions before the people if they make MKK responsible. So, my lord, with this background, where my lord, the grandfather benefits by reason of liquidation of the
father.
Yes, father. My lord, we interact with the next generation.
No.
So I end up by mistake saying grandfather. So, my lord, your lordship is right, my lord, father. So, the example the tea garden example which I was giving, maybe on pen and paper, he gives 2 floundering businesses to his sons. He doesn't apparently get anything from the businesses. But what he actually gets is, he ensures that he will not be held liable or responsible for anything. That's the consideration. The large bank liabilities on foundry. Brother also ensures that he's not indemnified from anything. So I am given, my lord, a debt-ridden foundry division with a debt-ridden factory land and a debt-ridden shut factory. On the other hand, he's got, my lord, machines which are, my lord, even then showing, even in those times of, my lord, those bad times, even then, my lord, they are assets, and he's got a good business, and he takes it away into his own company. And I have this debt-ridden company. Now, kindly see in this, my lord, backdrop, my lord, please see the family settlement once. I will not place it twice. Once, my lord, on the anvil of ownership and once on the anvil of management. Now, my lord, let me start on the anvil of ownership. Please see clause 1. The foundry work will be looked after by RKK independently. And he will be owning and accepting all liabilities of the same. So, my lord, I am owning liability and I am accepting liability. Or, my lord, if your lordship reads it otherwise, which I think is a better way of reading it, foundry work will be looked after by RKK independently and he will owning. Then there's a conjunction and accepting all liabilities of the same. Make proper admission before the people if they make Mahesh and KK responsible. So, my lord, Mahesh is indemnified. I look after it and I'll be owning it and accepting all liabilities. Even, my lord, even if this doesn't give me ownership, if this owner, because there's a question of ownership of a liability. That's, my lord, a absurd contention. So here owning should be read as owning. Liability is liability. Whatever it is, even if my learned friend, he's argued and he will argue that it's only acceptance of liability. But even acceptance of liability gives a corresponding right of ownership of the asset. Owning and accepting all liabilities. Let's take it at face value. If I own and accept all liabilities, I get some rights in the asset also. And I'll make admission to people if they make NTK responsible. So he is the indemnified. I tell people also and I ensure he is not held responsible. Then, please, my lord, now read clause 11. 1 and 11. This arrangement has been done, keeping in view all concerned would act diligently and promote own business and bring the family out of the mess. So, my lord, own. Twice, my lord, own. Now, my lord, I read it. This was done in Hindi by my learned friend's client. And it's translated to English. Dekhega is looked after. So dekhega, in a more colloquial Hindi or close Marwari Hindi. Marwari Hindi, even it's not, Marwari is a separate language, but when Marwari speak Hindi, there is a certain dialect or a way of expression. Wo dekhega, ye dekhega means that says. And that, is translated to English. And owning and accepting. Owning, in clause 1 is a very important, facet. I would submit, the word owning could be, read with acceptance of liability. I own something and therefore I accept the liability. Or if you look at it the other way around, I accept the liability, therefore I am the owner. And if there is any dispute, please read it with 11, my lord. Promote own business. So one has to be read with 11. Otherwise, we not look at an absurd contention. I'm sorry, an absurd interpretation. The interpretation I'm suggesting is you're owner of machine, I'm owner of foundry, it's my own business, that's your own business, and I will tell others if they hold you responsible for foundry liability, then it's my liability. This is below a clear below interpretation. Other interpretation is you will manage and look after machine. I will manage and look after foundry. Neither of us own anything. We all own it jointly. Yet, you can deal with, that's in the later clauses, which I'll read. You can deal with assets in Millard machine. I can deal with assets in foundry. The ownership Millard is rendered to a nebulous situation in that, which is not possible. And conduct of the parties will show Millard that it's ownership which is under contemplation. Now, Millard, please see 2. RKK will provide necessary paper for NKK to resign from the company. So he has to go out of the company under the family settlement. Machine work with all liabilities will be tackled by NKK. He will own and is a conjunction. Own and accept all liabilities. वो उसका है और वो liability उसका है. The conjunction is Milord so clear, so explicit that it divides Milord or it creates a barrier between ownership and liability. One gets ownership, one also gets liability. I've never heard of a situation where I'll only get liability and I will not have any ownership. This is not contemplated. Especially with a rider that he can't come back in. And I can't go into machines. Both, now 4-wheeler, both are free to sell their properties for augmenting business and for liquidation of debt. This Milord is corrected by father. And he says sell. Lordship remembers Milord the affidavit that this was corrected by father. And he says sell. Then up to 4. So he can sell, I can sell. Unless you have ownership, how can you sell is the question I ask myself. And why this partial restriction? Partial restriction is to ensure that if you sell off, it must be for paying off debts or for growth of business. Because there are debts to do. So first you clear your debts. Then Milord, up to 4 is regarding this. Now from 5, 6, etc. 5 and 6 really is Milord a recognition of the patriarchal status of the father. In a Marwari household, where both brothers are with the father, they refer to father as Babuji. If you don't, Lord, at least on the face of it, do anything contrary to Babuji's wishes. So, Lord, it's even at that juncture, Milord, the status of Babuji and his position in the house has to be maintained. So, Milord, 2 things are done. You give accounts to Babuji. And Milord, the house and office expenses will be joined. 5, Milord, is qualified by 6. Supposed to provide monthly account to MMK. the house and office expenses will be joint and will be paid 50-50 from September 2002. Any of them can pay and subsequent accounting will be done. Any less contributions from either will be made. Same office, same house. Till the time it's all liabilities are, which is what Dr. Kejriwal also said. Till the time liabilities are worked out, this should continue. And they will, I don't have it with me, I'll bring it on the next day. They have something like a day book. We call it in Marwari as the roker. And every expense pillar is entered. Father admits, details, etc. So 5 and 6 are to give patriarchal supremacy to the father. That at least over home and for joint expenses, you remain at the head. Maybe you've, in consideration of your liabilities being wiped out, you have divided between your sons. But at home, you will remain at the head. Then below 7. Indian Bank, Punjab Bank will be tackled jointly, liability paid 50-50. Go down, office property sold, and payment of
Now all these 50-50 liability are cleared.
50-50 liability. Yes, clear.
All clear.
NKK has put forward his application about personal guarantee to Vaisa Bank, which RKK has made arrangement so that NKK is not affected. So I have to make arrangement so Vaisa Bank doesn't disturb. This arrangement will continue till joint bank liabilities. So this is not till joint. This arrangement has been done keeping in view all concerned would act diligently. So, my lord, this is the family arrangement. Whole judgment of the company law board is on interpretation of the family. That was because what was complained of by my lord, their attempt to come back into the company. And my attempt to take over the company was the issue in the company. And the defense was the family side. That you've got nothing to do with this. Now, my lord.
So they have also filed their company petition. They were the petitioner.
They were the petitioner.
On the strength of this family settlement.
No.
Your shield is the family settlement.
Then I have got the, now what has happened? It's been below 15 years. 30, no, the impugned order started. I have always seen this matter. Just after I joined, I think company petition is of 2006. 3-4 years after I joined. So from 2006, before that, family settlement of 2002. In the meantime, what has happened is, machine is doing very well. I've got Parijat's balance sheets. Show this year's balance sheet. Hundreds of crores is the turnover, or thousands of crores. He's doing very well.
No, Mr. Choudhury, those are really
extraneous.
Relevant.
Not relevant. I have also.
Most relevant part is, let us look at the company petition. What was the case matter? And then, of course, what was your defense in your reply?
And the third thing,
and on the basis of that, how the CLB proceeded.
And the findings.
Naturally. Because the rest are immaterial. These are all circumstantial, maybe prejudicing factors. But the thing is to come to the court dispute and how was it adjudicated? That's the issue.
I agree. May I just add something also, if your lordship permits me? Another fact which company law board could not have looked at, but because your lordship in section 10F is considering a CLB judgment, And those judgments are there which say that CLB has to take note of subsequent events. So your lordship will also take note of subsequent events. If your lordship sees the judgment between me and him, Miller, things are clear.
No. If the subsequent events are post judgment,
Yes.
then the views are there. Company law board should have been granted an opportunity to take those into consideration, to revisit the issue.
And if we go, we're finished.
That's right.
We'll never go back.
That's right. Now, the tenant court sitting on appeal on questions of law, correct? But sitting on appeal, it takes these subsequent events which are post judgment, then it will be really a fresh adjudication of semantics by the tenant court. Will it not?
Miller, I tell your lordship why. Your lordship will also put an end to matters complete.
Totally. Agreed.
So for putting an end to matters complete.
I'm continuing with 402.
Yes.
The moment I'm sitting in 10F, I'm
40.
continuing with 402.
So just one fact, Miller, your lordship will take note of while using 402. That is, Miller, death of father. That's the only subsequent event which is of any relevance. Now, as on the date of Miller, the judgment, it was me, him, father. Between me and him, Millard, CLB has no problems. CLB has Millard ensured that he has no right in respect of this company. But CLB, Millard, what I challenge is
the death is post judgment, post CLB judgment.
So, Millard, my submission is that the whole confliction, Millard, today, my fight, Millard, is really on a much lesser pedestal. Because when I, father's share, when I, Millard, challenge the judgment, what did I challenge? All the findings square me and him are in my favor. All the findings square my company and my father are against me. I challenge those. Now with father no longer there, and the findings, Millard, between me and him binding us both, Millard, those father's shares, even if I assume, Millard, the will is good, will be hit by those. And to do complete justice, your lordship will not deal with that.
As to deal with that, I do not know what shall be the fate of the probate proceedings. I don't know. Had the will, if the will is being upheld, will stands, then situation is one.
But that's my second case.
Right.
My first case is, Millard, my first case, in fact, I shouldn't say this now. I should, Millard, put forward my first case. Clause 1, clause 11 says own.
Your first case should be, look at the document as 333, this family settlement, and you read the judgment of C. That should be your first case.
That's what I mean.
Because your sheet answer in defense is this document, 333, page 333.
Yes.
Now, whether the company law board where has he gone wrong in the light of 333?
Kindly, Millard, take the test.
So let's first take the company petition once.
Very good. Part 1. My learned friend, Mr. Vasu, I don't know why, Millard, perhaps I missed it, gives me a judgment yesterday. I don't recall reading it, but really enriched me. 1962, Millard, 5 learned judges of the Supreme Court are held that question of interpretation or interpretation of a document itself is a question of law.
Which question of fact and law?
A question of law in a second appeal matter. I thought I was looking at perverse interpretation. What is perversity? It shows me the judgment. Ramaya Milord has the judge, Bombay High Court judgment. Where reading this while interpreting a family settlement, Bombay High Court holds that interpretation of this settlement document is a question of law relying on Chunilal, that 62 Supreme Court. Then I read 62 Supreme Court and I am astonished, Milord. The question of interpretation, constitutional bench says, is itself a question of law. I hadn't realized. Then I looked up, Milord, other learned judges, Milord, have also proceeded on that basis.
Another thing, now the moment interpretation and construction of this document comes, 333, the family settlement. Then this is an admitted document.
Yes.
Execution admitted, purport admitted, content admitted, whatever is written there is admitted. Now, how to be looked at it?
Interpretation.
You may look at it in a manner X, you may Y, I may Z. Whatever. But interpretation will be purely on the face of it.
Yes.
Because in 397, there is no scope for earlier, yes, but what we have seen and we have grown up and thereafter,
no evidence.
No evidence. No evidence action. No witness action, rather.
Earlier, your lordship has seen
I have not seen. I have heard from Mr. Mukherjee. I have heard from Mr. Senior Mukherjee, Mr. Sen, that Justice Shulil Rai Chaudhary, court number 8, as his lordship then was. We have heard those.
I think 15 years his lordship took the company court, maybe 15 or 20 years.
And what are the judgments? He had been winding up, be it in 397. And 397 is one of the most fine, excellent jurisdiction where you will have to apply Trust Act, you will have to apply transfer property, apart from Companies Act, concept of partnership, concept of even somewhere succession, all branch of 397.
That, Milord, 397 should never have taken to its seat. At least the appeal should have been here. It's being made a dead jurisprudence.
What a fine jurisprudence.
Yes, to come back to it, Milord, as your lordship said, I can't expect, Milord, I can't expect evidence. It has to be on the face of it. At the best, surrounding circumstances. At the best, but mainly on the face of it. Milord, please take Milord page 1.
Let's see the reliefs.
Yes. 1. Milord, from page 54. Board be superseded.
What's yes. Would be superseded.
Would be superseded, then
Committee
committee constituted, proportionate representation, declaration.
These are all
usual prayer, board meeting, further shares.
What's declaration that the board meeting purported to have been convened and held by the purpose of amendment of capital clauses. Declaration that the extraordinary board meeting. Order for cancellation. Here comes the important bit.
This he is not got.
Roman 7.
Yes. No, my lord.
Order for cancellation.
Roman 7.
Yes.
Oh, this is below further shares, allotted shares. This I think he has got. Yes, that's been allowed. What he hasn't got, which is crucial, is 16 at page 56. That is below neither here nor there. I can do that again.
Order 16, Roman 16.
Yes, this he hasn't.
Order we made for cancellation and deliver of the fraudulent transfer of 1025.
Then fiscal injunctions.
And he has not asked for invalidation of this family settlement. No declaration.
No. Nothing.
Cancellation of family settlement.
No. Doesn't refer to it.
But he has pleaded.
Yes.
The
Page 24.
Nation.
Because in fact, this starts from page 23. We are 6.23 at page 23.
1 second, sir. Yes.
In the meantime, irreconcilable disputes and differences arose by and between the petitioner number 3 and the respondent number 2 inter alia on account of failure to settle diverse event of the respondent number 2. As a result whereof, the petitioner number 1, father and uncle Dr. V.K. Kejriwal intervened in order to bring peace. Inter alia formalizing arrangement pursued on 10th June on 1996 on the following list. So admitted that this is pursuant to the 96 understanding, and then he Millard types it out. Copy of the understanding arrangement. Then Millard, in conformity with the letter and spirit of this understanding, petition number 3 resigned from the board and continued to look after machine works.
So he admits the execution.
Yes. Then Millard, he says, respondent number 2, in violation of family, I understand, failed and neglected to redeem mortgage, accept the letter of resignation furnished by the petition number 3 from the board of Hanuman Foundry, pay household office expense, clear liability of ICI Bank. There is no Millard outstandings.
Now, let us see the impugned order.
Yes, Millard. Kindly take Millard. There's a notes of argument which we filed that has a copy of the impugned order. It's easier to.
One spiral binding, you have said that you will bring?
Yes. Don't tell me, Ashwini. I'm sorry, they've spiral bound and got Millard judgments, but I'm not submitting it because I want to change most of it.
Why?
I'm going to add some judgments.
You make a second compilation, no issues. These are all submitted.
Yes, yes, I have no problem. I'm going to rely on this, but I thought I'll make some. So I've given you one.
Index scheme.
What is this preliminary note on behalf of the appellant?
That's without my note.
Preliminary note. Why preliminary?
Then I think you could file a further note.
Reserved your right.
Yes, sir. हमने क्या चेक कर लिया है तो ना ना
Take it back.
No, there are two. I'll make another copy. Please, kindly look at my preliminary note.
Correct.
In fact, I'll bring a spiral copy from the next day.
Very well. No,
After the note, my lord.
no, you just take me first to the improved judgment.
Yes, because there are two enclosures to the note. One is the family settlement, and then below is the impugned judgment. Very convenient, which is why I brought your lordship.
No, that's all right, but which page is the improved judgment?
Milord, which
Date, date and page.
date? 14th May 2013, volume 6, page 3699.
Volume 6, page 3699. ঠিক আছে, তো এখন ছোটটাই দেখি, এটা লিখে রাখো।
And will refer to internal page.
হ্যাঁ, এসিটা চালান তো। এটা এসিটা চালান, এইটা ওইটা দুটি চালান।
And I was taking the note on the iPad.
সাইবার ক্রাইম 26 আছে, তো ওটাকে 20 করুন, আমার ওইটা চালিয়ে দিন। 20 করে দেন, হ্যাঁ ওইটা একটু চালিয়ে দিন, একটু বাদে দরকার, হ্যাঁ পরে দরকার ওটা বন্ধ করুন। ইয়েস মিস্টার চৌধুরী।
Then I'll read it out. The patriarch Murali Mohan Kejriwal, MMK P1, his younger son Mahesh Kumar Kejriwal, MKK P3, and daughter-in-law Alka Kejriwal, P2, have filed a petition under such and such, alleging acts of operational mismanagement in Hanuman Talking Mills Limited by the elder son Ramesh Kumar Kejriwal, his wife Saroj Kejriwal, their son Ankit Kejriwal. Wellcast Products Private Limited, R5, the company promoted by RKK, and Narendranath Sen, whose appointment as an additional director in HCM is under challenge, have also been implemented. Third, admittedly, one Pratappal Bagadia and members of his family promoted HCM on 12 July 2022 and continued to run the affairs of HCM to the HCM owned a valuable asset, that is 24 acres of land. Kuleshwar, land was at all material times used by Hanuman Foundry, a sister concern of cotton mills on monthly rental. It is not disputed that the Kejriwal family had carried out 5 registered partnership firms as A. Shubhadra Trading Company, D. Murali Mohan Agarwala, C. Shubhadra Export, D. Shubhadra Scrap Flow, E. Vinay Steel. Between 1975, 76 and 89, 90, all the partnership firms had made considerable profit. And since most of the buyers, consumers were foundry works, the Kejriwal family decided to take over both HCM and HF as a measure of forward integration of the family business. This resulted in takeover of HCM and HF by the Kejriwal family.
What is HCM and HF?
Miller, Hanuman Cotton Mill and Hanuman Foundry. Cotton Mill Miller is the owner of the plant and the lessee of the land. Foundry is the owner of the land.
So foundry and cotton mill are the same. Same now.
Over. Your HCM Miller, Cotton Mill is the owner of the land, and Foundry is the owner of the plant. And
Very well.
Foundry is also.
But
the
now
lessee.
both are under your umbrella.
Yes. Now we have another entity called Wellcast, which I think is the lessee of the land, and it's Miller carrying out the business.
Very good.
Business has grown Miller considerably, and we are all debt free. All family debts are all Miller wiped. I mean, at least Miller, the foundry debts are all wiped. Machine debts were never. In and about March 1990, the government of India changed their policy with regard to distribution of steel of scrap arising out of the slackdown of sale. As a result, we were business of the firm gradually started to dwindle, and eventually the Kejriwal family decided to wind up the funds, and they are now in the process of being wound. About December 1989, after the takeover of HCM and HF by the Kejriwal family, shareholding of the parties was under. The father has 1040, mother has 1000. He has 1250. His wife has 860. I have I'm sorry. I have 1250. My wife has 860. He has 12,025.
No, but these facts and figures are not disputed.
All admitted. All facts are admitted. There is no dispute. Even in the judgment, other facts are also admitted. Apart from notice of meeting, etc., etc. Those are inconsequential.
Inconsequential.
But whoever is in control can appoint a director tomorrow. So if one is set aside, it's of no consequence. In 18, paragraph 5, 89, 90, 97, 98, HCM was trading in foundry products manufactured by HF. It is not disputed whether I have to take over the HCM and HF from Bagadias. Eventually, RKK and MKK were the directors in HCM. Admittedly, the last page of the annual returns filed by HCM for the year 1999 bears signature of MKK, and the annual return filed by HCM shows appointment of ANK as additional credit. Not disputed that disputes and differences arisen between MKK and RKK in 1996 with the intervention of Dr. Kejriwal, uncle of MKK and RKK. A family arrangement was arrived between them, under which the day-to-day administration and business of Hanuman Foundry was to be looked after by RKK, and the machines belonging to the partnership business were to be handled by MKK. The family arrangement was signed and accepted by the three parties. Admittedly, business of HCM dwindled between 2005 and losses were reported. It is also admitted that MKK had shown personal guarantor to the loan advanced to by Vaisa Bank to Hindustan Company. According to petitioners, in around 1996, the irreconcilable disputes and differences arose between MKK and RKK on account of failure to settle diverse dues of HCM under the management of RKK. As a result whereof, Uncle VKK intervened and was able to formalize a family arrangement between RKK and MKK on 10th June 1996. The said family settlement was reduced to writing by VKK and signed by Sadhguru 29 September 2002 and read as under. Then look, this is set out. The petitioners, allege that in conformity with the letter and spirit of the aforesaid family arrangement, MKK resigned from the board of directors of HF. And this is not his assertion. But page 7. In conformity with the letter and spirit of the aforesaid family arrangement, MKK resigned from the board of directors of HF and continued to look after the machine works under a company Parijat. However, RKK, in violation of the understanding under the FA, failed and neglected to, it is my failure, redeem mortgage involving land, accept a letter of resignation furnished by him from the board of Hanuman Foundry. At that stage he was scared, he wanted to run away. Now he wants to come back. 3. Pay household office expenses and taxes, electricity charges, result whereof petitioner was constrained to pay 50,000 rupees. Clear liabilities of Vaisa Bank or redeem mortgage of the land. Notwithstanding the fact that all the other assets of Hanuman were sold ostensibly for payment of dues of the bank. it is further alleged that on or about 3rd February 2005, there was an assertion of right by RKK before MMK that all shares held in the capital of HCM by the petitioner group must be transferred to RKK and SK. This request was denied by MKK on the ground that HF was entrusted merely for the purpose of running of day-to-day affairs and question of transfer could not arise. Strangely, the petitioners alleged that later on 11th February 2005, MMK was shocked to find that all the share scripts in the capital of HCM and HF were missing from his Almeida. Upon intervention by his brother VKK, RKK returned and restored possession. This goes to show that HCM and HF, being a family company, share scripts were always in the possession of the patriarch. It was also noticed by the petitioners that wanted equity sales, such and such. This is all disputed. In 12 million, this is regarding an EGM.
No, these are the alleged violations.
Yes, 12 is important, Miller. 12 last sentence is EGM for transfer of 1025 shares held by MKK and HCM. His shares. He challenges below that. And paragraph 14, below, he says that it's void. So he says, I did not and I need not transfer your shares.
Show me the finding of the
Yes. That goes on. His case, my case, paragraph 46. 3 paragraphs is the judgment. And it's completely on the family settlement. Internal page 29, paragraph 46. It is well settled rule of interpretation. Answer.
Yes.
It is a well settled rule of interpretation that a document required to be interpreted must be read as a whole. While interpreting the family arrangement, it must be borne in mind that the situation as prevailing in June 1996 and not in September 2002.
There was one judgment.
Yes.
In the context of 397 also. Maybe the judgment was rendered in a suit or whatever you proceeding. How to interpret a family settlement? There is a judgment.
How to
interpret a family settlement of a closely held family?
Kali.
I cannot remember.
I think it's Kali. I was doing a matter before Justice Kapoor the other day for interpreting a family settlement.
In fact, I learned this judgment from the father of it.
His Lordship told me who find that judgment.
And then I learned it while doing a matter from his senior Kapoor.
So that's when he told me. I went and looked up and I showed him Kali and he agreed that yes.
I
have a feeling it's Kali. And
I learned it from him when we were doing a matter relating to a mining company. No, we were
Sarfaraz.
Maybe.
Yes, Sarfaraz.
Yes.
Odisha mine.
Yes.
Sarfaraz.
And
Sarfaraz. Mr. Ratnesh Rai.
Maybe I was doing
your Lordship solicitor. Yes.
And Mr. Kapoor showed us that judgment. We learnt it from Mr. Kapoor.
IBR Millard, he was an advocate, senior advocate from Delhi who used to come. Then Millard, team was changed and we came in and we got Mr. Abhindu Mitsu. But then by all this is a subsequent event. After your Lordship came this time. Now, but since we are on this, let me indicate that fight is going on. We couldn't get through this. We have not got any substantive relief. However, the other brothers, your lordship's clients, and that there was another group, represented by Argus partners. Now they have started fighting.
More the merrier.
More the merrier. This time I am appearing for them. Yes. Will kindly see page 131 of the compilation.
I will.
I think it's the judge.
Maybe. Let's proceed on this. 46, Mr. Chaudhary.
It is a well settled rule. I read that would have to be considered because the need for family arrangement arose in June 96 on account of irreconcilable disputes and differences arising between two brothers, that is RKK and MKK. And I agree with both findings. It must be read as a whole. And number two, situation prevailing, see from 96 onwards. Then paragraph 47. Bearing in mind the above, the theory that the family arrangement arrived on 10 June 1996 to settle the disputes arising between MKK and RKK was a complete family partition is negated by the following facts. But if your lordship looks at the family arrangement, while Miller giving ownership, step one is ownership divided.
No, you are saying that by virtue of this document, it was really a family partition in every respect.
Yes, but the question which the court posed to itself, Miller, that I'll just read that, was a complete family partition
is negated.
Now, one must bear in mind, Miller, that my interpretation of this document is also it's a partition, qua ownership and control. However, till payment of liability, there is a jointness. Because guarantees, because he and I can agree, I am indemnifying him from the bank. It's not binding on the bank.
Of course, unless the banks are.
Correct. So that's why, Miller, lordship looks at a few clauses that till bank liability is paid, certain things have to continue together. So therefore, the question, the complete family partition, is perhaps not correct. It is a family partition by which ownership and control of the family assets is divided, and it's also decided how liabilities are to be met, and it is also decided that till the time liability is met, you may have ownership, you will only sell to meet liability or improve business. Once you finish your liability, discharge everybody, go your own pace. That's what comes out of this. Now let's see this. The preamble of the family arrangement of June 1996, reduced to writing on 29 September 2002, clearly indicates that it was to separate the working and liability and not to separate the ownership. Clause 1 also uses the words looked after and not owned. Wrong. Now please look at the family settlement now. Single page print to have one. But would your lordship keep this on the side? I am doing it, so I thought it's very useful. But please, Milord, see this one again. Preamble of the family arrangement of June 1996, reduced to writing on 29 September 2002, clearly indicates that it was to separate the working and liabilities and not to separate the ownership. Why? Clause 1 also uses the words looked after and not owned. But clause 1 does include the word own. Let me see clause 1 now. RKK independently and he will owning. Grammar, my lord, is obviously not a strength of the family. Now, this is ignoring material on record. Also, my lord, when you say that you say looked after, I'm going by literal interpretation. You look at clause 1, there is an owning in the clause which you ignore, and you also ignore clause 11. Please see clause 11. Promote own business. So, my lord, this finding, which is paragraph, I will not show your lordship, each paragraph is so inherently flawed. Each, my lord, interpretation is so perverse that this judgment, my lord, really has no legs to stand on. So, one, my lord, is, my lord, total violation of 1 and 11. 47.1 is contrary to 47.1 and 11. Only reason given in 47.1 is looked after and not owned. Ignored that there is owned in both 1 and 11. Now, my lord, please see 2. Clause 5, which required both MKK and RKK to submit monthly accounts to MMK, clearly militates against the concept of transfer of ownership and leads to an inference that under clause 5 of the family arrangement, overall control and supervision over the work of both divisions, that is foundry division and machinery division, was to be done by MMK, as both sons, that is MKK and RKK, were to provide monthly accounts to the father. Now, my lord, what is ignored here is
Yes.
Lord, clause 5 is relied upon. That
4. You are on Roman 3.
2 pillars. 2. 2 says that monthly accounts have to be submitted. That militates against the concept of owning because it shows that overall supervision is to be done by MMK. But it's father. That's the finding. Now, Milan, I want your lordship to consider 2 things. Number 1, clause 4. Both are free to sell their properties. And there's another clause. Yes, I'm sorry, it's clause 4. Both are free to sell their properties. That's not considered when you say overall supervision is father. It's not considered that there's freedom to sell properties. Second thing, it's not considered. 2 things, below. Number 1, this arrangement of supervision is really a recognition of the patriarchal status of the father in the family. You don't insult your father by telling him you are nobody from tomorrow. What do? You give him accounts. Why? I retain my right to do whatever I want with my business. I retain my right. My job is done. But I respect him. I give him accounts. I also give him accounts of home and put concrete on the status of father at home. He is welcome, my lord, to reject tuition expenses of grandchildren, which he has done, some of it. So, my lord, this is A, this is out of respect. B, it does not, my lord, impinge on control that each of us had over our divisions. C, this is primarily related to office, a joint office and home. And D, all of it was only, my lord, operative until the time the dues are not liquidated. Now, these crucial facts which will not come out of the document are will not ignored in number 2. These 4 bullet points ignored while coming to this finding. It's a very simplistic view of the document. A, it's a myopic view because you don't look at a half of it, you look at a clause, look at it in isolation and read it. And B, it's a very simplistic view, not reading the document as a whole, as the learned judge has held it should be done. Now, please see 3. Clause 4, read with clause 11, clearly depicts that the object of the family arrangement was only liquidation of debts and to bring the family out of the mess. Admittedly, the family remained joint in mess and residence. Please see, 4. Both parties are free to sell their properties to augment in business and for liquidation of debt. And then, please see 11. This arrangement has been done keeping in view that all concerned would act diligently and promote own business and bring the family out of the mess. Now, also, C10. This arrangement will continue till joint bank liability is liquidated. According to me, 10 is very important.
After that, what will happen?
What will happen? That's the question. And I answered the question by saying, please look at 1. I loan. And I also request your lordship to see 3. Machine work he will own. Then I'll say, please see 4. Sell off your properties for augmenting your business. And then 5, 2-9 is what's going to happen till liabilities are met. And that's clearly said by 10. That this 5 to 9 will continue till the time liabilities are met. Ownership and conduct of parties show that they separated. He took everything. It's part of it was before the CLB. It's before your lordship.
What you were saying.
Yes.
I will see from record also.
Yes.
That after receiving this machine part, he had transferred the assets
to Parijat.
Whatever.
And then onwards. And I don't grudge him that. I don't grudge him his 100 crores, 1,000 crores.
Yeah, no. The moment he has transferred assets from the machine division, the moment he exercised his right of ownership.
Yes. I'm grateful. That moment.
The moment he transferred, the moment he exercised his right of ownership.
And that evidence.
Now, if on the strength of one document, if one uses its right of ownership, on the strength of the same document, under the same situation, can you say the other one will have not
will not have a similar
right?
That is it.
Yes.
That's Millard. So here, Millard, I was on this that this concept that own is temporary till liabilities are met, then everything will come back again together and we will start fighting like cats and dogs. That below is not clear from the document.
Very well. For the time being, you show me,
Yes.
as on date, how are you affected with this judgment? Because of the father's situation. The finding.
Kindly come to the directions. Page 45, para 60. First finding is against my learned friend. Paragraph 61. MKK is not entitled to any relief in this petition, as having divested his entire shareholding in HCM, that is 1025 shares held by him in favor of RKK in the year 1999. He has ceased to be a shareholder. So my learned friend is not my shareholder.
And he has challenged that.
He's challenged that. It's failed.
No. In appeal.
Yes, that's another
in his appeal.
That's his appeal.
Yes.
So, Milord, he's not a shareholder. Now, Milord, two. Family arrangement was intended solely to bring a complete demarcation of management responsibility. I am unhappy with this. Between the two brothers, RKK and MKK. Separation of MKK from Hindustan Cotton Mills, Hanuman Cotton Mills, was thus essentially intended under the family arrangement. So, Milord, it's been held two things, Milord. Number one, management responsibility. Why only management? What about own? Secondly, Milord, it goes on to show that there is a division between him and me. And there's also a finding separation of MKK from my company was essentially intended under the family. So this is in my favor. So it's all against him. He has no right of ownership. The family arrangement does not intend him to have any right in my company. That's in my favor. But this management responsibility is, Milord, not correct. Secondly, Milord, the fact that the division is only between him and me, between the two brothers, is perhaps not correct. But, Milord, on that date I was unhappy with father. Today, Milord, it's him and me. Father is not there. Subsequent event.
Father's right under the said family settlement was to a very limited extent, just to be indemnified in respect of the loans and liabilities.
Exactly.
That is the only right father had.
Only right, father.
The moment it can be demonstrated on record, from record, that his entire liability or loan, whatever,
yes,
in effect, liability was taken care of.
That's it.
His right, he has no more right under the said agreement.
Under the agreement in respect of the company. So that is Milord. But then when one says that this was a separation between the two brothers, and you don't, Milord, say that the father did not retain any right but to have his liability met. That's Milord the purpose.
The moment his liability is squared off.
Yes.
Then what is his right under the family settlement? Nothing.
But it's his obligation not to interfere in the company, and his shares really vest in me.
Because that is always because the moment father has reserved his right only to that extent. And if ultimately we come to the conclusion after reading the one-page settlement, read with the judgment, that the rest are taken care of by the father by dividing equally between the two. What he has thought. What he thought of, he did it.
Yes.
Therefore, only to the extent of indemnity in respect of liability, nothing more.
Absolutely. That is
Now
my
the
case.
moment the liability is cleared off, squared off,
It was.
right? Father cannot claim any right. Now it is really between fight or a mutual arrangement or staying together or staying apart between the two brothers. Between the two brothers.
Exactly. Pursuant to 3, my lord, pursuant to the family arrangement, MKK, who was better placed under the family arrangement, had transferred the entire machinery received by him to his company Parijat Vyapar. This is the learned judge's finding. Pursuant 63. Pursuant to the family arrangement, MKK, well, that's Mahesh, who was better placed under the family arrangement. That's because machinery was worth more. There's also a finding to that effect.
MMK is the father.
Yes. And
MMK is the father, MKK is the father.
MKK, who was better placed under the family arrangement, had transferred the entire machinery received by him to his company Parijat and others. The value of such machineries being in excess of the value of the land owned by HCM. Under the family arrangement, ownership of land by HCM was not intended to be transferred to RKK, who along with Patriarch, MMK and other shareholders, excluding MKK, had proportionate share in the asset owned by HCM.
Again.
Under the family arrangement, ownership of land owned by HCM, which is below cotton mills, was not intended to be transferred to RKK. So ownership of the land doesn't come to me, who along with MMK and other shareholders, so RKK, that's me, father and other shareholders, but excluding my learned friend Mr. Mitsu's client, had proportionate share in the asset owned by HCM. Now, interestingly, what court does is, court sends him out.
But the moment, say the cotton mill, let's say 4 shareholders are there, only 4 own 100%. So the cotton mill land, though the company is the owner, but the shareholders are in control, right? Technically, shareholders cannot be said to be the owner. They are in control. Now, so long the other shareholders remain, let's say 3 remains out of 4, along with 4. So the 4 cannot claim any right under their shares.
The 3 remain as shareholders.
4 shareholders are total.
Yes.
Right. Under the settlement, let's say this type of settlement, the company has gone to 1. One of them.
Yes.
But the 3 of others,
other 3,
they are still
can't
holding.
claim right.
Huh?
They're still holding. They can't claim any right.
That's
on the
right.
strength of their shareholding.
No, but they are still holding the shares.
Yes.
In the company. So as shareholder, they have a right to the extent a shareholder can have.
Yes.
Not on ownership.
Not ownership.
Certainly no. No shareholder can claim right on the ownership. But as a right of shareholder, whatever right they have.
Now, my lord, I add to this. When, my lord, there are 4 shareholders and these 3 shareholders under a family settlement don't have a right in respect of the asset or the business, then, my lord, the shareholding right, because it's a family company, is made subject to the agreement. Their right, we shareholder, is subject to agreement.
But those shares are, so long the shares are not really transferred, in effect.
On the face of it, they are shareholders. But the moment you try to enforce your rights in the company,
yes,
you are liable to be thrown out.
The family settlement will be a sheet.
Be a sheet.
Right. But those shares are required to be transferred.
Yes. Or cancel, or transfer.
Whatever.
No, in that situation, my lord, you, my lord, by saying that other shareholders have a right, is, my lord, the problem. So what is being done is, my lord, father and mother is being given right in respect of the asset. That's the problem. Now, my lord, 5. HCM shall rectify its register of members by showing transfer of 1025 shares held by MKK.
So here the company law would, according to you, should have directed that you 3 shareholders immediately transfer your share or relinquish your share in favor of RKK.
Oh, yes, all would stand cancelled. That also
Whatever. I mean, their right should be taken up.
Yes.
Taken up by whatever mode and right.
Now, my lord, if not then now, the subsequent event, death of father, if not then now, nobody can claim any right. I'm putting his best case. He says that I got my father to write a will in my favor. May write a will. When you give the will to the company will give you your shares. But then, when you go to vote, or when you say I want to transfer these shares, or I want to exercise my right, my shareholder, member, etc., that's when, my lord, the family settlement will act as a shield for the company and for me, and will, my lord, repel you. It will be a firewall. It will prevent you from encroaching upon the company. And that should have been the finding of the judge. Then, my lord, 5. HCM shall rectify its register of members by showing transfer of 1025 shares held by NKK under folio number 96 to RKK and adding such shares in favor of RKK so that his shares and the owner. But why only 1025? His wife has another 800. You should have also held that those 800. The appointment of ANK as additional director are bad. That's not irrelevant. Resolutions are bad. I'm not on that. Allotment of equity shares, that's irrelevant. I can do it again. Other additional director, that can be done again. Now, Willard.
Now we read 61.
61 and 62 is regarding land. There was an injunction with regard to fixed assets. So, Willard, they complained that there was a breach of a status quo order. It was then, I'll read it, Willard. This will show, Willard, what they're trying to do to the company. Willard, another important thing, Willard, anti-company activity is something which weighs heavily with the court because your lordship's jurisdiction is primarily protection of the company. Now, my lord, 2 things I'll say. This conduct and present conduct of having 50% of the company's factory removed will go heavily against them. My lord, they say that there was a contempt. I said that, my lord, this foundry business. We make molds, they make manhole covers for all over the world. So, my lord, there are molds. Those molds, my lord, they put iron into casting. You don't need, my lord, a fully enclosed factory shed. So, what they did was, there was a status quo order. They put up temporary construction. Not really status quo order, it says, take out the order. It says, don't do something which is irreversible or something. So they put up, steel struts, put in a asbestos shed. That was also done over land, which was earlier not, which earlier had a shed. It had broken down. Ages ago there was a shed that had broken down. So on top of that, we put these steel struts and put the asbestos and put molds, and because operations have now increased manifold, we can't create a factory because of the order.
Well, Mr. Chaudhary is arguing for
Said that this is illegal construction. Changing. Justice Tandon was issued a rule. We in fact admitted in our affidavit that we have done. This is what we have done. It was required. This is not full construction. This is not in breach of the order. I have done this. Justice Tandon said no. This is not correct. So, my lord, of our own, faced with contempt, faced with blood, they obtained an order for demolition. And my lord, we went to Supreme Court and had it stayed. If they go in and demolish everything, they'll demolish the molds, all the machines, everything. So, my lord, we had that order stayed by Supreme Court on a Saturday. When, my lord, the demolition had started, then we went and told my lord, Justice Tandon, because it had come back for reconsideration, that we will take it off on our own. Please don't order demolition. And then you decide the contempt. We thought this was not contempt. We have done it. We are sorry if it's offended you. We'll take it off. And we took it off. And we put in reports. Special officer went again. Special officer was satisfied with regard to most of it. And we've taken it off. So while, my lord, they bask in the glory that they have persecuted me to remove, my lord, half my factory. When, my lord, it comes to a company matter relating to this company, my lord, this is an anti-company activity. There is no finding of contempt till today. Yes, I can say that I prevented the directors from acting contrary to an order of court. So that's not anti-company. There is no finding of contempt. Today, what have you done? You are consistently persecuting the company into reducing its business to less than 50% by removing its factory.
My
It's
learned friend is
anti-company
talking about
activity.
Bhutan.
It prevents you from not having any equitable consideration in your field. Now, Millard, please see para 61. This is the first chapter of persecution before the company law. During the pendency of the petition, CA number such and such was mentioned by the petitioner on 13th July. CA number such and such paid for an injunction against the respondent numbers 1 to 4 from creating any mortgage, charge, lien, encumbrance, lease on the land belonging to HCM. The board on 13th July 2009 ordered maintenance of status quo as on date with regard to the fixed assets. Thereafter, CA number such and such was filed by the petitioners and mentioned on 25th. It was stated therein that in breach of the status quo order dated 13th July and in connivance with RKK, the nameplate of HCM has been removed from the premises of HCM and the nameplate of WC, a family company of RKK, has been affixed. It is also stated that a huge chimney and a shed which had been built by WC, that's not well cast, in the premises belonging to HCM, photographs have been filed on 9th June. All the respondents gave an undertaking that in the event it is held that construction by R5 is in contravention of the order, they shall remove the construction. There is not an iota of doubt that the construction activity undertaken by RKK through WC on the land of HCM is clearly in breach of the status quo order, liable to be removed. In view of my finding that the allotment of equity in HCM to WC is bad in law and set aside, R5 has no legal right to remain. I therefore direct RKK and WC to remove the entire construction by WC on the land of HCM within 2 months. So, Wellcast is my, this is first now. This is not what I was telling your lordship about. This is Wellcast is my company. It's been given a lease on the same land and it's put up a factory. I'm sorry, a chimney. Because these are furnaces which have to be done. Then, in view of a finding recorded by me, shareholding of HCM on the date of the petition is such and such. Prevent any act detrimental. MMK and RKK. So me and father shall be joint signatories to the bank accounts. I further direct that pursuant to my finding that allotment of 95,000 shares to RKK, 1,30,000 shares to such and such are illegal and being set aside. Consideration shall be refunded. Then below 65, I direct that HCM shall take steps for transmission of shares held by mother. This is wrong. When you are directing this, the company law board should have not recognized that the family arrangement would act as a shield. So, my lord, this is, my lord, if your lordship looks at the whole judgment, I have lost when it comes to my father
and mother.
and yes, father and mother, and I have won when it comes to him. So the learned judge, my lord, the company law board appreciated, my lord, that this I have independence in the company insofar as he is concerned. But, my lord, that put me jointly with father. While it put me jointly with father, my lord, the problem which I faced and the problem which my lord has multiplied now, problem I faced insofar as mother, para 65, and the same problem I faced with father, whether it is succession or it is, my lord, inheritance, ultimately, my lord, he is going to come crawling back into me through that. So therefore, my lord, to put an end to matters complained of, it should have been clarified. I would have understood that.
And the family settlement has to be taken as it is, as on the date of its execution. As on the date of its
execution, 2002.
So the moment as on the date of its execution, and if ultimately it is held that the family settlement speaks of exclusion of father to the extent of securing his liability,
Yes.
otherwise subject to securing
Subject
his
to securing his
liability, or subject to whatever, securing his liability, indemnifying him, and the moment indemnity is granted, immunity provided, no further loan, father was not touched, father's right comes to an end.
Yes.
And mother has not been spoken in the family settlement. Mother has not been whispered in the family settlement.
Because
so how the mother came?
That is the point, and the effect of this pillar becomes a problem. The effect pillar of 65 is to achieve something.
Now take a situation. If your contention is taken to be correct, that you are the only and only for foundry, then what will happen to the mother's share?
Mother's share, my lord. Mother's share goes to pillar and this.
Mother's share has come to Mahesh.
There's no bill, so interstate. He will get divided. Again, he'll come crawling back in. That is the problem. Should have been appreciated.
They have not made out a case for the mother, not even argued that mother's share should have this should have happened to the mother's share, this should have happened to the mother's share, not even argued. My learned friend is making out a new case now and wanting the court to make out a new contract between the parties.
So, similar, when you're construing the family settlement, this is similar to the problem. You're effectively coming to a conclusion he doesn't have a right. And again, we are giving him a right through the.
No, but you think it equally that very well. Father, even if it is said that father has relinquished everything from the said company, subject to be indemnified.
Yes.
On for his liability. And the moment liabilities are covered, taken care of, father is made free. So he cannot claim any further right under the family settlement. at best. But how can you remove the mother?
Well, only one thing, one very small submission. Well, that the father was a party to the family settlement and the father had relinquished his right to the shares, that is not pleaded, that is not urged. In the pleadings, your lordship will not find any mention of this. And well, we must remain true to the pleadings. The parties are shackled to their pleadings. They cannot now make out a new case in the course of arguing an appeal.
Nobody is making out a new case.
Lordship will look at the pleadings. There's no such case.
The judge,
No.
the judgment. Please read the judgment.
No, I'll take your lordship to the pleadings. My learned friend is arguing
After I complete, sir.
Yes.
Now, this is the remaining judgment, my lord, is a result of argument. My lordship, I'll show you before this that this is what was argued. So this, again, if your lordship comes back to 57, 47.
Which 47?
Paragraph 47. Please continue.
Yes.
Now, please see, my lord, 6. I read up to, my lord, 5 and then 6. This is about resignation, which I will place on the next page.
47?
Paragraph 47, my lord.
Roman 6.
Yes. Why this was not a complete partition?
No, the theory of transfer.
Yes.
The
Theory of transfer 1025 shares is also consistent with the fact that to reconcile the disputes and differences between RKK and MKK, a complete demarcation but management responsibility of the respective divisions was essential. It has been stated in para 6.23 of the petition, RKK was in charge of the management of HCM, responsible for the failure to settle disputes. Therefore, clause 2 of the family arrangement, under which RKK was to provide necessary papers for MKK to resign from the company, must be held to mean that MKK was to resign from the board of directors. Although the petitioners have tried to place an interpretation that MKK was to resign only from HL, and paragraph 6.24 of the petition stated he did not resign from the board, yet the petitioners have not placed any document to substantiate this. In para 6.24, MKK did not state when he did not resign from the board of HL. Also not shown if MKK had held shares in HF, etc. If irreconcilable disputes arisen between MKK and RKK family arrangement, it is most unlikely that MKK would have signed blindly annual returns of HCM. Then it goes on. It was held that he was on the board because in the time the liabilities are met, he continues. But what is very important is if I draw your lordship's attention to page 34. Finding 8. At the relevant time, that is in 1996, the value of the machinery received by MKK under the family arrangement was more than the value of the land owned by HCM. So at that point of time, this is reflected clearly by the balance sheets of Parijat, Vinayak Steel for the relevant years.
No, but how they are material? These may be a prejudicial factor, but how they are material? Because adjudication will have to be made on the basis of family settlement and its content, right? Now, that is why I was asking this question, that let's say if the family settlement is upheld to the true spirit and writing of it, then what will happen to the mother's share?
Mother would travel with father.
How do you say mother is not whispered? So long father being a party to that settlement, yes, very good. Understand.
That what would effectively mean is
The entire company, entire foundry business to continue, be it whatever way it is.
and machine is his. I can't interfere. I can't interfere. And if there is your lordship, what your lordship said is right. What about shares? What will you do with them? The right now, when you read these documents, you provide clauses for transfer, cancellation, etc. This is parties doing it themselves at home in the middle of the night, so those clauses are not there. What will happen? Answer to that is family settlement. Whenever you yes, shares are in your name. Law requires shares will be in your name. But when you go to do something with those shares, the family settlement will be the fire between you and the company.
No. When you will be going to do some work by executing or exercising your right as a shareholder of a company,
yes,
can a family settlement stand as a shield to that who is not a party to the family settlement?
The company.
No, the mother's shares.
Mother's share.
Father, yes. Let's say two brothers in their own way, yes, let's say. But the strangers to the family agreement
yes,
who have shareholding, what will happen to them? Can this family settlement be taken as a shield as against those strangers?
Milord,
Father, yes. Two brothers, yes.
even if Milord, I am looking at it from practical aspect, as a commercial. What will happen? Mother had 800, 900 shares. Now, Milord, mother's shares will start getting divided. Some shares, maybe 300 shares would go to him. Again, for those 300 shares, when they ultimately, any share which ultimately reaches him will be not turned ineffective. Because this is all the beneficial interest in the share being transferred. Family is the owner. Concept is the family is the owner of the company.
No, but how can the CLB or Tenef Court shut its eye on this factor that X is a stranger to the family settlement? He is not a party, he or she is not a party. Forget about the mother, whoever.
Yes.
Let's say an outsider. How can you put a shield before him or her, the family settlement? Even if she is not the mother, she can transfer the share in his favor, he or she, even if he or she is an outsider to the family. If one is a shareholder, he can transfer the share.
No, that's correct. Here, Milord, we have to approach it in the concept, Milord, that these are family. It's a family company, these are family assets. If it's a Mitakshara, he, Milord, goes where the father goes. For example, like my wife goes with me. His wife goes with him. Milord, in real life, Milord, none of it happens. There, Milord, I was his wife. He is the one who is obedient. There's a reason. That time, Milord, when he was getting married, I was the only one there for him to discuss all this because we were both there in Mr. Mitro's chamber morning to us. So, Milord, like in this matter, the relevant time is 96 to 2002. At that time, Milord, I am the one who can give primary evidence. And Milord, what has come? And Milord, the real reason I am the one who can only person who can give it. Right?
That is the moment you enter to the First Avenue.
Yes.
Los Angeles also. First Avenue.
We used to discuss with her that what will happen to the stock. Stock when I came to her, he said that will there be a division like this? So there is a now he's getting senior, so he's more affected by this. Stock here.
Give me a date.
Yeah, nobody else.
No, give me a date. You concerned? Give me a date. 2 p.m.
Ask Mr. Shah, my lord.
Yes. Mr. Shah,
Mr. Chaudhary is arguing, so my lord, he can
I
do
am
it.
any date is good, my lord.
Mr. Shah, what is your convenience?
My lord, Mr. Chaudhary is arguing, so my lord, I suppose it will have to be his convenience. I am my lord there.
No, I am good with Mr. Shah's convenience.
And I leave it to your lord.
Order a कागज पे लीजिए.
I leave it to your lordship, my lord. Apart from the 20th, my lord, any day is convenient.
No, any day next week.
Mr. Jishnu Chaudhary, ওই একই অর্ডার হবে, হ্যাঁ, ওই দুটো অ্যাপিলকে একসঙ্গে করে অ্যাপিয়ারেন্সও একই হবে, সেম অ্যাপিয়ারেন্সও একই হবে. তারপর লিখুন Mr. Jishnu Chaudhary, Land Council, for the appellant in APO 210 of 2013 is continuing with his submissions. He shall resume on the next day. Mr. Krishna Shaha, Senior Counsel, being the Senior Counsel for the respondents in APO 210 of 2013 and applicant in APO 211 of 2013 shall commence his argument after Mr. Chaudhary concludes.
Right.
Paragraph, by consent of the parties, both these appeals shall appear under the heading for hearing bracketed specially assigned, marked at 2 p.m. on
Next week, not Wednesday, Tuesday, Wednesday.
Calendar को बता
Not 17th, not next Wednesday.
वो तो एक तो হবে, হ্যাঁ, 24 17
No, or 18th.
17
Yes.
Yes.
January 17, 2024. Thank you, Mr. Shah. Thank you, Mr. Chaudhary.
Grateful.